The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I will begin by calling the calendar, so please listen carefully. People versus Obligatov is submitted. Lalo versus New York City Department of Education for the appellant.
Good afternoon, Brian Glass for appellant Julie Lalo.
Five and one.
Five and one is fine.
5 and 1.
Yes.
Would you like something? Were you going to say something less than that?
I was going to say maybe 4 and 2, or
I'll give you 4 and 1.
5 and 1 is fine. Thank you.
5 and 1, it is. And for the respondent?
This is Ellen Ravitch for the respondent, New York City Department of Education.
5 minutes.
Thank you.
Monique J. versus Keith S. For the appellant, the appellant has submitted. For the respondent?
Good afternoon, this is Shanice Hinkson.
I didn't hear the end of your appearance, but Ms. Hinkson, the appellant has submitted. Do you want to argue against yourself? Do you want to argue in any case?
Yes, yes,
okay.
Please.
Okay, 2 minutes. Booston LLC versus 35 West Realty for the appellant.
James Fishman, Your Honor. Can I get 6 and 2, please? 6
and 2 for the respondent.
Warren Estes, 6.
6 minutes. People versus Gerard Gonzalez is submitted. Millette versus 111 John Realty for the appellant.
Appellant, 111 John Realty, Kevin McArdle, 5 and 1 is fine.
5 and 1.
Defendant, appellate, respondent, 7.
Just a minute, please, if you don't mind, if you would just wait a minute, please. Thank you.
Nicole McCord for defendant, appellate, respondent, 7-11.
Okay, 5 and 1.
Yes.
And for the plaintiff respondent?
Paul Crennis for the plaintiff respondent, Millette.
5 minutes. Thank you. People versus Albert Vega for the appellant?
Harold Ferguson for appellant Albert Vega, 4 minutes on direct and 1 in rebuttal.
4 and 1. For the respondent?
Yes, Megan McLaughlin for the people.
4 minutes.
Thank you.
Shanahan versus Erico International for the appellant.
Jeffrey Fegan for the appellant. Mary Underbow.
Thank you. 6 and 1. And for the respondent?
Jason Weinstein for plaintiff respondent. 6 minutes, please, Your Honor.
6. And Kurovskaya versus Project OHR for the appellant.
Good afternoon, Your Honor. Kevin O'Connor requests 6 minutes and 2 rebuttal.
6 and 2. For the respondent?
Good afternoon, Your Honor. LaDonna Lusher, Virginia, and from Virginia and Ambinder for the plaintiff respondent. 6 minutes, please.
6 minutes. People versus Ronald Jackson for the appellant.
Matthew Bova, 6 and 2, Your Honor.
6 and 2 for the respondent.
The people request 6 minutes, Your Honor.
I'm sorry. Could you give your appearance, please?
Yes, Sheila O'Shea for the people.
6 minutes.
Yes, thank you, Your Honor.
Just to let you know, Justice Gonzalez is recused from that case and Justice Gish is vouched in. I'm going to call the case out of turn and it will be called first, okay? Turner Construction versus Mount Auburn for the appellant.
Good afternoon, Your Honor. Stephen Kaplan from Kaplan Left, the appellant. 5 and 1, please, Your Honor.
5 and 1. For the respondent.
Good afternoon, Your Honor. Greg Chertoff from Bakar Nabinson for the respondent. 5.
5 minutes. Crawford versus Ali for the appellant.
Good afternoon, Your Honor. David Kornblau from Covington and Burling for the appellant, like 6 and 2.
For the respondent.
Good afternoon, Blair Greenwald on behalf of respondent Judge Ali, 4 minutes.
4 minutes.
And Paul Anderson.
Respondent.
Paul Anderson for respondent, DA Clark,
4 minutes, please.
And that's 4 minutes. GLCA Securities versus AGC Networks.
Good afternoon, Your Honor. Kevin Schlosser of Meyer Swazi, 6 and 2, please, for the appellant.
6 and 2. For the respondent.
Good afternoon, Your Honor. Noam Besden of Amini LLC for the respondent appellant, 6 and 2 as well.
So there's a cross appeal, so 6 and 2. VXI Lux versus SIC Holdings. For the appellant.
Good afternoon, Your Honor. David Heck for the appellants, and with my colleague Jonathan Weiss, who I will request later on to appear pro hoc vice.
Okay, 7 and 2. For the respondent.
Good afternoon, Your Honor. William Dayhill, Dunnington, Bartholomew Miller for the respondent. 6, please.
6 minutes. Vulo versus Park Insurance. There are 2 appeals. For the first appeal, the appellant.
Yes, Michelle Jacobson for the appellant, second Ledan.
7 and 2.
7 and
For the
2.
respondent.
Good afternoon, Your Honor. Eric Del Pozo for respondent, the state. 7 minutes.
7. And for the second appeal, it's submitted. Nosnick versus NJS Carpentry. For the appellant. I'm sorry, that's submitted. And Romero versus Smith is withdrawn. On the third case, Monique J versus Keith S. That case, Justice Gonzalez has also recused herself, and Justice Gish is vouched in on that as well. So I will be calling that case first, followed by People versus Ronald Jackson, and then we'll resume with the first case on the calendar, or the first case for argument on the calendar, which will be Lalo versus New York City Department of Education. Counsel, please remember, as always, that we have your briefs, we have your record, we're fully familiar with the facts of your case, so please go directly to the most important parts points that you wish to make. Also, as is customary, please don't speak while a justice is speaking. This is particularly important, of course, during virtual arguments so that you can hear one another and hear the question that's asked by the court. Finally, please keep your mics muted unless you are actually the person who is speaking, even after your case is called. And with that, I thank you for your patience and cooperation. I'm not sure if right now everyone's mics are muted. Mr. Fishman, I believe your mic is not muted. If you can hear me. Okay. We're ready with the first case, which is Monique versus Keith S. Ms. Hinkson?
Thank you, Your Honor. And may it please the court, my name is Shanice Hinkson, and I'm an attorney at Simpson, Thatcher & Bartlett, appearing as pro bono counsel for the respondent, Monique J. This is a case about a devoted mother who seeks to protect herself and her children. The family court appropriately exercised its discretion when it issued a 5-year full stay-away order of protection against the appellant father. In January of 2018.
What's the burden here to support a family offense?
Here, the burden to support a family offense is.
Is it a fair preponderance of the evidence, and was that met here?
Yes, it is a fair preponderance of the evidence, and that was met here. Here, the respondent testimony was completely corroborated by police report, photographic evidence, and testimony of the residential aide who came to her assistance during this January 2018 incident. During that incident, the father pushed her, forcing her to cut her lip. He then pulled a box cutter out of his pocket, held the blade to her neck, and threatened to slit her throat, all while the children were present in her home. The father was convicted in criminal court for his conduct during this January 2018 incident, And here on appeal, he makes no legitimate argument that the family court had no basis for its determination that he committed 5 family offenses.
Yeah, Ms. Hinkson, this is Judge Gish. I have a question. You talked about the respondent's convictions. Isn't it true, though, that the convictions were for crimes that were lesser than the crimes which form the predicate for this order of protection?
Yes, that is
Does that
correct.
make a difference?
It does not make a difference here.
Why?
Here, the mother's testimony was enough to show that the father's conduct in both instances in January 2018 and January of 2015 was enough for the family court to find that he committed 9 family offenses. Her testimony was detailed. The family court has the discretion to determine the credibility of a witness. And here they determined that his testimony was self-serving, inconsistent, and utterly fantastic.
So then, Ms. Hinkson, there would be no basis, in your opinion, to in any way find that the credibility findings by family court should not be given deference?
In this particular situation, the family court should be given full deference because they had the entire record. They were able to, he was able to be cross-examined by the opposing attorney, and they had all of the record evidence to make that determination. So here, this court will not need to disturb the family court's findings at all.
Any other questions from the bench? Are you finished?
Yes, I was just going to ask if there are any further questions.
No, I think there are not. Ms. Hinkson, you did this case pro bono. I thank you for taking on pro bono cases and thank Simpson Thatcher for sharing you. Thank you very much.
Thank you so much.
Next case is the people of the state of New York versus Ronald Jackson.
May it please the court, Matthew Bova for appellant Mr. Jackson. This case involves a straightforward application of this court's holdings in People versus Rodriguez and People versus Z. Under People versus Rodriguez, the waiver of the right to counsel here was invalid and unconstitutional because this record does not confirm Mr. Jackson's awareness of his maximum exposure of 12 to 24 years. And
Counsel, it seems that on different occasions, there was reference to a different plea of 5.5 to 11, I think, and at another time mentioned that he had a mental illness or something in the record. Is that enough under the case law to substantiate a hearing?
So I'll take the first issue first, Your Honor, which is the sentencing exposure and what the record demonstrates regarding that. And then I'll move on to the Z issue. So as for what the record indicates as to the sentencing exposure, the record here is exactly like the record in Rodriguez. In this record, on arraignment and in May of 2013, now the waiver happened 6 months later in September, but on those 2 dates, May and at arraignment, there was an indication of a plea offer of 5.5 to 11 years. But Mr. Jackson's exposure was 12 to 24 years. And as this court held in Rodriguez, knowledge of half of your sentencing exposure is not enough. In Rodriguez, this court squarely held the defendant was facing 15 years, and the record may have demonstrated that he was aware of a sentence of 7 to 8 years. But this court held for that reason, and that reason alone, that the waiver was invalid, because the record does not sufficiently, and I quote here, does not sufficiently demonstrate defendant was aware of his actual sentencing exposure of 15 years. The court's failure to ensure the defendant was aware of his sentencing exposure mandates the conclusion that his waiver of the right to counsel was invalid. That is
Does it matter also? I mean, I know that you're talking about the full exposure, but does it also have any effect on the searching inquiry that that 5.5 to 11 was talked about 4 months earlier? as opposed to at the time of the inquiry, or whatever an inquiry should have been.
Well, Rodriguez indicates that if the record shows prior to the inquiry that the defendant is aware of his exposure, it's not necessarily required that it happened at the colloquy. The better rule is certainly that this happened at the colloquy. But in this case, this court doesn't have to really reach that question because the record at no point indicates, whether before or after, that he was aware that he was facing 12 to 24 years. That's the critical issue, is that Mr. Jackson, this record does not indicate that Mr. Jackson was aware that he was facing his maximum exposure of 12 to 24 years. And in fact, this case is even worse than Rodriguez, because what happens here on November 7, 2013, 2 months after Mr. Jackson purportedly waives his right to counsel, he actually reaches out to the court and he says, "Your Honor, how much time am I facing?" And the court affirmatively misadvises him regarding his sentencing exposure. The court tells him he's facing 3.5 to 7. The court then asks the prosecutor, "Is that what you have too?" And the prosecutor says yes. So not only does this record indicate that Mr. Jackson was unaware of his sentencing exposure of 12 to 24 years, but after the waiver, he asked the court about his exposure and the court affirmatively misadvises him and then gives him a sentence of 12 to 24 years.
Thank you. I want you to have time to go refer to Z. So why don't you move to that issue?
So Z is an alternative and independent ground for reversal as well, because here under Z, the rule is where there are red flags demonstrating that the defendant may lack the mental capacity to waive his right to counsel, the court must conduct an inquiry into that issue. And here there were red flags all over this record. Mr. Jackson is found incompetent to stand trial by 2 doctors. That is a rare occurrence in our court system. It's very common for defendants who have mental illness to be found competent to stand trial. But here, he was found incompetent to stand trial by 2 doctors. Those doctors, as in Z, noted that Mr. Jackson had delusions, that he was hallucinating. One of the quotes from the record of the 730 report, when he's asked regarding any history of hallucinations, he states, "Nope, nope." On the other hand, he readily owns and verbalizes paranoid persecutory beliefs. And then the doctor quotes him, "In the dormitory, I know I'm being watched at the behest of the one who put me here, Judge Berkman. She doesn't like what I speak." The doctors also recommended that he receive inpatient psychiatric hospitalization and psychiatric medication. They diagnosed him with 2 mental health disorders recognized by the DSM, psychotic disorder, NOS, not otherwise specified, and mood disorder, not otherwise specified. He then, after these competency evaluations, he writes letters upon letters to the court, which are incoherent, incomprehensible, and confirm that he still is suffering from mental illness at the time that he ultimately is asked to waive his right to counsel in September of 2013. So we're not saying here that this record conclusively confirms that he lacked the mental capacity. All we're saying here is that under Z, that an inquiry had to occur.
A searching inquiry. Thank you.
Thank you, Your Honor.
Ms. O'Shea?
May it please the court, my name is Sheila O'Shea and I represent the respondent on this appeal. With respect to the issue of sentencing exposure, as the court knows, in Rodriguez, the court recognized that the court is free to look at the entire record, the record as a whole, not just the day that the request to proceed pro se was granted. And I further submit that the court should in fact—
Was there anything in this record that apprised the defendant of what what he was facing?
Yes.
What the parameters of what he was facing completely?
There were several things, some of which my adversary referred to. First of all, at the arraignment, the prosecutor suggested the prospect of consecutive time. He also indicated that the defendant was facing significant prison time. Now, this is a defendant who had just served 17 years in jail, so I don't think he was talking about 5 necessarily to 11, but those are the first 2 things. More important—
But counsel, you're saying you don't think. I mean, I recognize what you may or may not think. The issue is what the defendant knew and what the defendant was told. And so you're saying he was told that it was significant time at arraignment, but at the time that he was at where he actually inquired as to how much time he was facing, the court apparently stated, "I haven't even looked because we haven't discussed it." and then said that it would be 2 to 4 and a maximum of 3.5 to 7. And that, I think that was on the auto stripping only. So
Yes.
again, how does this, I'm a little familiar with Rodriguez since I actually wrote the majority in Rodriguez, but I'm trying to figure out how that really comports with Rodriguez.
Right, Your Honor, that's fair. As you indicated, the judge herself on 11/7, when the defendant rather questioned the court about his sentence exposure, said he was facing a minimum of 2 to 4 and a maximum of 3.5 to 7 on the auto stripping count. However, contrary to what my adversary said, the judge also pointed out that the defendant was charged with multiple counts of 3rd degree and 4th degree criminal mischief and possession of burglar's tools. Now, admittedly, the judge did not raise the prospect of consecutive time. However, I think that Rodriguez... Isn't that a major omission by the judge? Well, I'd like to get to that, if I may. I think Rodriguez is distinguishable from this case in 2 significant ways. I'm sorry, if I may. First of all, consecutive sentences were not an issue in Rodriguez, if I recall. I just read the decision today. I don't remember consecutive sentences being on the table. Second of all, in Rodriguez, unlike here, the judge said nothing whatsoever to the defendant about his potential sentencing exposure. The only thing that people had to rely upon in Rodriguez was the defendant's own statements as to what the defense attorney told him, which I think the defense attorney suggested he should take the 7 or 8 years offered by the people. And the defendant also made a statement that he would enter a plea of 5 years. So it's distinguishable in those regards. And I think that this court should look at Rodriguez with the Second Circuit decision in United States versus 4 as a backdrop. I don't think the 2 cases are necessarily contradictory. I think that Rodriguez can be read in light of what 4 says. 4 talks about, and again, in 4, there was a discussion, or consecutive sentences were an issue, even though it was unlikely that the court was going to impose a consecutive sentence. However, what the defendant argued in 4 was that he faced a potential sentence of up to 125 years, which is 5 consecutive sentences of 25 years each.
Well, counsel, what I do not understand is the whole issue is whether or not the defendant can make an intelligent determination as to how they will proceed. So that would mean, I would assume, that the defendant has to have all of the significant and necessary knowledge. The fact that the defendant will be facing consecutive time, or could be sentenced to consecutive time, would seem to me to be something that is significant and something that the defendant should be appraised of prior to making a determination.
Well, the judge did not ever.
So the judge says 2 to 4, 3.5 to 7, but never mentions the significant fact that could be consecutive with the other sentences.
That's right, Your Honor.
I mean, that is something I do not understand, and I did not understand your argument in your brief that, you know, it was fine that she only told him as to the auto stripping and not to the other charges. But the other issue is, even if assuming that you stray from Rodriguez, as your adversary stated, as you're arguing, what about the fact of the defendant's competency in terms of his mental competency and his ability, therefore, to represent himself, his capacity?
Yes, thank you, Your Honor. I'd like to address that. I think, again, this case is distinguishable from Z. I don't think at the time that he requested to proceed pro se, there were any so-called red flags of severe mental illness. Admittedly, back in November of 2012, 2 doctors had found him not competent to stand trial. However, my adversary relies only upon the psychiatric diagnoses made at that time. That was in November. In March, after the defendant had spent over a month at Mid-Hudson Psychiatric Facility, the doctors concluded that his psych, and I'm quoting from the model report at pages 2 to 3, March 13, 2013, defendant's psychiatric condition significantly improved. He understood his legal options and the severity of the charges against him, and he was determined to establish a relationship with his lawyer. And I submit that now that's a good 6 months before he even asked to go pro se. I submit nothing at the time of the request.
I think that's 4 months, from November to March?
No, I'm sorry. I'm talking about March March to September with a, I'm getting confused about it. I'm not good at math, but whatever it is, it's 4 to 5
But the
months
fact
later.
that he had a history and the fact that he was engaging in this activity in terms of these letters, which were bizarre, you're stating that there was no responsibility, no burden on the judge to at least inquire as to his present mental capacity?
I don't think that as I attempted to argue in my brief, the July 1st letter in particular, what the defendant was asking for in that case was a reevaluation of the finding that he was not competent. He also demonstrated his knowledge of the legal issues in the case when he talked about the necessity of the people.
Wait a second.
Yeah,
The judge, I think the evaluation, sorry, the evaluation here has to be about whether or not the person can represent him or herself. You know, even when you're asking someone about a plea, and I'm sorry, I can't think of the word right now, allocuting someone. Thank you. Even when you're allocuting someone, you ask them, have you had any drugs or alcohol? Have you had anything affect you? This is a higher burden, and you're saying the judge doesn't even have to mention anything about whether he's of sound mind? There's nothing here at all.
The judge has discretion not to address it, as this court acknowledged in Rodriguez, not to address it absent these so-called red flags of severe mental illness. I don't think there were any red flags of severe mental illness. Again, the letter of July 1st.
This is Judge Gish, and I was the author of She. I don't know that the issue for red flags is severe mental illness. And I think that the issue really is were there red flags to indicate that there was any kind of mental illness that would interfere with his ability to validly waive the right to proceed with counsel, to proceed pro se. Isn't that a different inquiry than competency to stand trial?
Well, that's a good question. I think in Stone, the Court of Appeals said no. I think it said that those were
they're the same.
I think that's
so. In other words, in your estimation, that once he was found competent to stand trial, end of story. No, because there was a red flag indicating that he had a history of mental illness that perhaps would have warranted some further inquiry. That, in my opinion, did warrant further inquiry at the time that he was trying to waive counsel or waive the right to proceed.
Yes, but as I said, he had been found competent in March. That inquiry, the initial request was in September, and then the discussion with the judge about the sentencing exposure was in November. So the last thing we've heard from the psychiatrist is not that he's suffering from psychotic disorder or anxiety disorder. We've heard that his psychiatric condition has improved significally. And I think
improved isn't a cure. I mean, the question is the court's burden to make an inquiry. I mean, did they leave it to the two physicians? End of case. They said he's competent. Done. We don't have to ask at the for the searching inquiry any part of it. So what did the judge do with respect to that?
The judge was aware that the defendant had been found unfit previously, because in the July 1st letter, the defendant himself complains about that. So it's not that the judge was unaware of his previous psychiatric history. Now, another thing I'd like, and I'm sorry if I'm not answering your question directly, but before I forget, I'd like to say that the defense attorney never asked the judge to conduct any kind of competency hearing or brought to the attention
I don't
of the
think
court.
I don't think it's on the burden is on the defense attorney at that time, especially where the defendant is stating that he wishes to proceed pro se. But at the very least, the defendant was taking medication. At the very least, should there not have been some inquiry by the judge as to whether or not he was still on his medication, what the situation was in terms of the medication, whether he had taken his medication that day, whether he was, continuing to take his medication?
Your Honor, if I may, I believe he refused to take psychotropic medication when he was.
Okay. So isn't that relevant as to whether he can, in fact, represent himself if he's no longer taking the medication?
He made significant improvement absent taking medication, and as a result of the different types of talk therapy that he participated in while he was at Mid-Hudson.
And this was based upon, and this was the report from March, where we're now in September, and he wants to go forward. Right. But nothing between March and September. Is that correct?
That's right, Your Honor. That's right. Nothing one way or the other. So what we have, the most recent indication we have is the July 1st letter, and I know there were other letters to the court. They are difficult to even. The handwriting is difficult to decipher in the letters, admittedly.
So we have a determination by the psychiatrist in March, right? And then in July, we have these bizarre letters. And then in September, he states he wishes to proceed pro se. But your argument is that even though we have these letters in July, there should not have been any further inquiry by the judge in September?
I don't agree with your assessment with respect that the letters were bizarre necessarily. Parts of them were strange, there's no doubt.
Okay, I'm sorry. They weren't
strange.
bizarre. They were strange.
Strange.
I stand corrected. They were strange.
But strange, even according to the case law of this court, which I can't think of cases off the top of my head that are cited in my brief, is not necessarily indicative of a lack of mental capacity to waive counsel.
I'll let you just finish wrapping up because unless there are other questions.
Counsel, not whether there should have been some inquiry by the judge as to his mental capacity and ability to proceed pro se and waive counsel.
I don't think you had the right. Was it a question? Would you like me to respond? Okay.
Thank you. Thank you. Mr. Bova. I'm sorry, I have your name. No, is it Mr. Bova? Yes.
Your Honor.
We're back to you.
So as for what the record shows at the November 7th inquiry, there is a reference to the existence of third-degree mischief counts, but the record does not show that Mr. Jackson is informed that A, what the sentences can be on those counts, and B, that 6 of them can run consecutively. And I think this is a particularly important problem in this case, because Mr. Jackson was charged with breaking 6 car windows. It is hardly intuitive that the sentence that you can get for that is 12 to 24 years. This is a drastic and severe sentence that Mr. Jackson, as a layperson, was not likely aware of. In this case, the need for this critical information, as Rodriguez explained, to be conveyed to Mr. Jackson was very clear. And as for the existence of a competency evaluation finding Mr. Jackson fit to proceed, that existed, and there's a whole bunch of evidence in this record that cuts directly in the direction of significant mental health problems that would undermine his capacity to waive counsel. All these issues should have been considered together at the inquiry stage. That is what Z required, and that's what did not happen here. Thank you.
Thank you very much. Thank you both. We are going to wait for Justice Gish to exit and for Justice Gonzalez to come back on.
Thank you.
Thank you.
Just close the door. Close the door.
Please turn your mic off until you're ready to speak. Justice Gonzalez? Justice Gonzalez? Okay, Justice Gonzalez is back with us.
Thank you.
Matter of Julie Lalo versus the New York City Department of Education.
May it please the court. My name is Brian Glass for appellant Julie Lalo. This is quite a historical case at this point involving a tenured teacher and teacher incompetency, which is a very difficult area in education. We're talking about a time period now from 2012 to 2015 where the state was implementing a new procedure called 3012C and trying to figure out how to deal with teacher competency.
But I think 3012C has to do with a pattern of ineffective teaching, right? Whereas what the charges that were sustained were charges that went to incompetency. So isn't that different from a pattern of ineffectiveness?
Well, I think the 3012C was a procedure that the state was trying to implement to get a handle on how they were going to handle the incompetence standard. And so this was newly implemented.
Aren't you conflating the two? Aren't you conflating the two standards?
Well, I do think that both procedure, the 3012C was being implemented as a procedure to establish a pattern of incompetency, and this is effectively why Ms. Lalo was found terminated here. But this was an attempt by the state to put some kind of rationality into the process. And so they had started down this procedure in the year one status in 2014-15. And then in the middle of the second year, when they were going to go to the year two status under this procedure for dealing with teacher incompetency, they stopped it. They decided to charge her in November of the second year. The reason they did that was because 2 years prior, when she had been rated ineffective by this teacher, they had a different program called PIP Plus, and the outsider, who was a former principal, came in and found Ms. Lalo was not incompetent at all. So we believe that in this case, what happened was she was concerned that if they continued with the year two status, that the outside observer, called the independent evaluator under this process, would have likewise found her not incompetent. Yes, it does appear this record
But
looks terrible.
There was evidence of 6 different classroom observations from 2014, 2015, 6 from 2013, 2014, and 1 from 2012, 2013. I think all of that was relied upon in support of the arbitrator's determination. So it wasn't just, wasn't just one issue, one event.
Well, what was happening was you're talking about someone who was a 29-year educator, who had been 10 years with the same principal, who had rated her satisfactory for many, many years, under the old standard, the SU standard, as a first grade teacher. In fact,
I think what you just said it is an old, different teachers come, different principals come, and they are evaluating. The evaluation was not just done by the principal. It's not something that she did personally. It was an evaluation that was over the course of years. And frankly, I think there's another instance where the teacher just, I guess she thought it was nonsense, because when she was asked to do something with a lesson plan, she ignored the principal. So, I can't tell you what, I can only tell you what the evidence is that I have to review here, that we have to review.
Yeah, but the record shows that this was the same principal. This is not a new principal. The same principal had rated her satisfactory for many years. The principal.
Then I can only say that she would know best, or that the people who she relied on to go into the classroom and observe.
So
what suddenly changes for some
counsel?
I'm sorry.
When you say she rated her satisfactory, those were in the years that you only had 2 choices, right? Satisfactory or unsatisfactory. And then the system changed and it got a lot more complicated, it got a lot more detailed with a lot of different ratings for a lot of different things, correct?
And this system itself,
when it was one or the other, she picked satisfactory. And then when the rating system changed, her evaluation changed. Right?
That's true. Yes, that's true. But then she got unsatisfactory. Then she had this outsider come in who rated her satisfactory, and she ended up satisfactory in the first of these 3 years at issue. So she ends up being satisfactory. The second year, because of this changing process, and you're right to point out that this changed a lot during this time period, she was rated highly developing. She missed effective in the second year by 1 point. And if actually had they waited a year, the process changed again by the UFT and the DOE.
Counsel, I don't understand your argument. You're saying that the process changed. It's not the process that changed. It was her teaching or lack of teaching skills that changed. And you seem to be arguing that because in the beginning of her 29-year tenure with the Department of Education, she received excellent ratings. That means that as the years progressed, she should have received excellent ratings as well. These individuals who came in, according to the record, who came in and observed her, etc., they found that there were deficiencies. So I think that's what we should be focused on, is in terms of their findings, as opposed to your argument that somehow the process changed.
Well, the question is, did her teaching change, or did the evaluators change how they were rating her? Because remember, it's the same evaluator who had rated her satisfactory.
Well, let me ask you this: are you
and
saying
the outside people have rated her satisfactory? So I don't think I don't think she changed.
I'm sorry, maybe you can't hear me. I'm sorry to interrupt, but I have to ask you: is the school not permitted to change its evaluation system, improve upon its evaluation system? It sounds like you have a problem with that Danielson framework, which my colleague referred to earlier, with a number of different standards. But that was the new framework that she had to.
And I agree with you. The Danielson changed 3 times during those 3 years, so that in fact the developing this year would be effective for 2013-14 would be effective now, because it was considered too harsh the way they were rating teachers. I understand this is a little difficult with the changing processes here, but the reality is you have a teacher who was charged, who had been satisfactory the first year, was essentially effective the second year. The third year she was rated ineffective and was going to work, had enrolled herself in PIP to improve herself. And so if you look at the record objectively, yes, it's very hard to beat paper. I understand this. If a principal says, I'm going to be in my APs are going to rate her ineffective all these years, I can't do anything about that. But I can say that a teacher who's 29 years, who happened
this is Judge Gonzalez. Sure. So one of the things that struck me in doing this and reading the appeal is the detail of the problems that were observed with respect to Ms. Lalo's teaching. What do you say about that? It's not just a check mark, it's detailed observation on many different occasions. 12.
I mean, these are administrators who were designed to write a file to push a teacher out, who for many years, and it was invalid. And you got to remember again, when outside interveners,
they stated, for example, failing to effectively plan the lesson, failing to ask proper questions and engage students in discussions, planning lessons that lack rigor, failing to provide students with meaningful feedback. I mean, these are all areas that they found that she was deficient in. So it wasn't like simply, as my colleague just stated, check boxes. They observed her and they found there to be deficiencies in these areas. So how do you address that argument?
Well, if you read just what your Honor wrote, I mean, effective, rigor, these are subjective terms that someone is making a judgment on completely subjective terms. That's why they were creating this procedure, because they were trying to create some objectivity to the process. And in fact, some of the categories you mentioned, she was not found. If you read the decision closely, the arbitrator threw out some of those as saying that was not, she didn't find her effective in all those categories. So again, I understand when you're saying it looks bad, but again, you're looking at what you just mentioned: rigor, effectiveness, not adequately. I mean, how do you design a system here for teacher incompetency that is objective for someone who's 20 years is fine?
So then, Counselor, how would you evaluate any teacher's performance?
Well, we were just, the main point in the brief was that if you look at this procedure they were creating called 3012C, they were trying to implement a system where if a teacher got 2 ineffectives, everyone would agree that the burden would shift to the teacher into proving competence. That's why they had created that system. The union had created the system because they were trying to put some level of objectivity to this. And what our main argument here is, why didn't they see the procedure through? She had enrolled herself in PIP. They were going to have an outside validator who would, before she had proven herself with an outside validator. The problem is that the principal who was out, and I could give you some motives as to why she was,
Well, you can do that on rebuttal then. Yeah. Okay, thanks. Okay. All right. Respondent?
Good afternoon, Your Honors. My name is Ellen Ravitch, and I'm here on behalf of the Department of Education. Julie Lalo was properly brought up on charges of incompetence and ultimately terminated from her elementary teaching position.
Counsel, Mr. Glass brings up the fact that this teacher has been in the school system for nearly 30 years. She was found to be, had good performance for a number of those years, until this very, he says, arbitrary kind of ranking system or rating system, sort of changed everything for her. Why is he correct, and why should we consider that?
Thank you, Your Honor. He is not correct, and that's because past performance obviously is not an indicator of present performance, especially when you have, or it could be an indicator in some cases, but when there's evidence that performance has changed, the Department of Education is certainly allowed to take appropriate action.
What about her continued effort and her enrollment in the program he speaks of?
Right. So under the old rating system, she had satisfactory evaluations for many years. And then before the period charged here, she had 2 years, consecutive years of unsatisfactory. That's under the old rating system. 2 unsatisfactory evaluations, and the department did not seek to terminate her at that time. Instead, they tried to work up with her. So she enrolled in this PIP Plus program, which she was entitled to do as someone who was perhaps on the verge of being brought or in danger of being brought up on incompetence charges. And this evaluator or this peer worked with her. And as he says, the peer did not agree that she was incompetent. And in fact, the principal also agreed that that year, with all of that help, her performance improved, and she gave her a satisfactory for that year. Again, indicative of the case that it wasn't as if this principal was out to get her. After 2 unsatisfactories, the Department of Education provided assistance, provided remediation, and she improved. But what happened was, in the years after that, she fell 2 years in a row. And while she wasn't still in the PIP Plus program, she was still receiving a lot of support twice a week from one other peer teacher and in other programs as well. And after the classroom observations in the second year being charged, which was 2013-14, the Department of Education found that, or the principal found that her performance had dropped, and she ended up with a developing, and then the following year it dropped again. And so it wasn't as if the department took this immediate reaction to poor performance and tried to terminate her. Instead, after 2 unsatisfactory years, they tried to help her. They tried to work with her. For a moment, 1 year, she did improve her performance, but she couldn't sustain it. And that's exactly what the hearing officer said. And so the Department of Education does not have the responsibility to keep giving its students insufficient education just because a teacher had perhaps good performance in the past. She was finally terminated really more than 5 years after her performance deteriorated. And this attempt to inject 3012C into this case is completely inappropriate. As Your Honor pointed out, there was no pattern of ineffectiveness charged here. Pattern of ineffectiveness was one way for the Department of Education to charge incompetence. And the difference is that with a certain number of ineffective ratings, then the department can charge that and get a rebuttable presumption of incompetence. That's not what happened here. And that statute did not do away with regular charges of incompetence, which is what she was brought up on here. And thank you. Is my time up?
Yes, your time is up.
Okay, thank you very much.
5 minutes.
Okay, thank you.
We're back to you, Mr. Glass. You have 1 minute.
Yes, just to point out, counsel, she had 2 years. An outside observer came in, a different principal from a different school, completely disagreed with this principal that she was not unsatisfactory, said she was satisfactory. The principal rated her satisfactory. The next year, she was basically effective. She was 1 point away from effective. And to say, so why didn't they move then? Why now? The real reason this is actually happening is that in the last year, she was, number one, the principal was worried that, an outside observer already had disagreed with her, and she didn't have control of the outside.
Counsel, can you address how your client fared with her teaching coach?
Well, with the outside observer, she was fine. With the coach, They did come in, but she was involved. She showed a receptiveness to improvement. In fact, she enrolled herself in the PIP program the
Didn't her
last year.
coach have difficulties with her because she refused to follow her teaching recommendations?
Again, the coach is under the thumb. The coach she disagreed with the coach, and the coach has to remove herself. The coach works for the same principal, Martinez. When outside people came in, they did not find her incompetent. And I just want let's finish with this final point. The real reason they moved on the timing of this is because in March 2015, she was physically, and it's in the record, she was physically threatened by the principal, and she reported her outside the school. Why do you think they moved in November 2015 to terminate her a few months later? Because she exposed the principal for threatening her. Why did they wait all these years? If she's really incompetent, yes, you could talk all day she's incompetent. Why are they moving in 2015 if they had this years of incompetency with her to do it then? You could see there's a motive behind these cases. Of course, the board has control of the grading process. They can't even be appealed. You have to understand the historical perspective of this is that, a principal is now she's become an enemy of the principal. Principal wants her out. If she was really ineffective, why was she not removed in 11, in 2012, in 2013? They had years to do this, right? So now they're jumping the gun.
Counselor, you're asking why did the principal give her a chance, right?
Why did the principal move in that particular period? If she was worried about an incompetent teacher at her school, who she was praising for years, in 2015, now we have to move against her, perhaps because she was reported for her own misconduct. And you got to think about this when you look at these cases, because you're right. That's why incompetency, that's why they were doing this. Okay, I appreciate the time. Thank you.
Thank you. Thank you both.
Thank you.
Booston LLC versus 35 West Realty Company.
Thank you, Your Honor. May it please the court, James Fishman for the appellant Booston LLC. Your Honor, there's a very simple and straightforward issue involved in this case, and that is whether or not it was proper for the motion court to permit the landlord of this commercial tenant to draw down on a bond that had been posted for a completely different purpose.
Was there any money paid to the landlord during this period?
Yes, absolutely.
No, I mean, there was money paid because the TRO, but so that there was, I'll call it use and occupancy.
Yes, there was.
That there was money paid because it was to, for the stay, I guess.
Yes, there was a stay.
So if that ended, was there anything else in place for the landlord to receive payment?
I don't know what you mean by in place, but
if that ended, what would have happened? If the court didn't then allow the drawdown, what would have happened?
You mean when the appeal was affirmed? When this court affirmed in July of 20?
Exactly.
There was no more stay because the appeal had been decided.
Exactly. So my question is, of course, then, so where would the landlord have gotten the money from at that point?
They still have a counterclaim in this lawsuit. And
so you're saying that the landlord would not have gotten any money then?
Well, they wouldn't have gotten it without a judgment or without establishing a right to the money. But you're asking, would they have just been able to grab it from the bond? The bond was always there to bridge this alleged $1 million gap in insurance coverage. Who
was the bond paid by? The bond had a guarantor, I imagine.
I'm not sure I understand your question, Judge. Who put up the bond? It was put up.
I'm sorry, not the bond. The amount of money that the drawdown. Where did the drawdown come from? Who was?
There hasn't been a drawdown, Judge. That was stayed by the court pending this appeal.
Exactly.
There is no drawdown.
But
right now.
Had Justice Sherwood's order been, if it continues, would it have been the landlord who was paying for it or the guarantor?
Who was paying for the bond?
If the money was being drawn down,
it would come from the bonding company.
Not the landlord.
No, the tenant posted the bond in order to protect against this alleged shortfall of insurance coverage.
Counsel,
and that was done.
Counsel, this is Judge Fishman. So the landlord terminated the lease.
Scarpullo.
Oh, yeah.
You elevated me, Judge. Thank you.
Oh, I'm sorry. I just want to ask you, the landlord terminated the lease, correct?
Yes, in
So
October
now
of
you are
19.
you are in the premises and you haven't been paying use and occupancy, even though you're in the premises,
Not
correct?
true, Judge. No.
You have been paying UNO?
Yes, we paid. There was a UNO directive from Justice Richter of this court, and that was in September of 19, that the stay was preliminarily granted on the condition that UNO be paid. It was
But that
paid.
ended. That ended.
It
right?
ended when the shutdown occurred, yes, in this restaurant.
And so that the question really is the question that I had. That's what Justice Scarpullo is saying. Right. Once that ended, there's no money being paid to the landlord. It was a simple question.
Oh, I'm sorry, Judge. I thought you were talking about July of 20. It was paid through March of 20, and then there was a shutdown.
Justice Sherwood did this because the landlord wasn't getting his money, wasn't getting any money. Isn't that the simple answer here? You're saying that it came from a different place, that the purpose of the stay, what was being paid for that, is ended. And so there wasn't, you're saying there wasn't a basis for Justice
The bond
Sherwood
technically shouldn't have
If you just let me finish, remember I made that statement in the beginning.
Sorry.
So you're saying that there wasn't a basis, there wasn't a legal basis for Justice Sherwood to get this order. Okay, but the simple question that you seem not to be able to answer was, is anything being paid without, if Justice Sherwood didn't put that in place, would anything, I mean, the idea was he was trying to get the landlord the use and occupancy.
And he could have.
I just wanted you to make sure you understood.
Yes, I understand very well, Your Honor. And I think what he could have done, but didn't do, in fact, denied, the landlord asked for a money judgment and ejectment. Both of those claims were denied by Justice Sherwood. And the only claim that was granted by Justice Sherwood was you can grab it from this bond that was put there for a different reason. And we're saying that the bond.
Judge Scarpullo again. So let me just make sure I understand this. The lease was terminated. You have no lease, and we all agree that there was no stay, no Yellowstone, so the lease is done. And the question now is, since March 2020, and now we are in May 2021, 14 months later, has your client paid any UNO?
They have not, Judge, because they've been out of business.
Your client has been in the premises on a lease that's terminated for 14 months without paying a penny. We're all in agreement with that, correct?
Since April of 20 is the first month that was not paid. That was during the shutdown, Your Honor.
So,
and for most of that period, they couldn't operate. They were.
I mean, look, we have a lot of.
So they have defenses. I'm saying. They have defenses.
13 months. Your client's in a terminated lease situation with no payment of rent.
You're right. And the remedy, there's a remedy for that.
I understand. I'm just trying to get the parameters to start.
Absolutely. Judge, we're not denying that. We're not denying that, but there is a remedy under 745.
This is Judge Gonzalez.
Yes, Judge.
I'd like to ask you about the parameters of the bond.
Okay. Well, I can point to you, Judge, to the order.
If you could say it, it would be simple.
Sure. The parameters of the bond was under CPLR 6312B, which is to cover any damages ultimately found to have been by an injunction. Here it was a stay. There hasn't been any ultimate determination. In fact, in this court's decision of July of 20, you said our right, whether or not we're in default under the lease, has still to be determined as whether or not the termination of the lease was proper.
So the crux of your argument is that you can't take money from a bond created for a particular purpose and use it for another purpose, particularly when that
and you said that, Judge, in the January 21st, 2021 order that was issued by 3 members of this panel. Justice Renwick, Weber, and Gonzalez were 3 of the 5 judges who issued the stay for this appeal. It says at the very end that the bond continues to as long as the tenant continues to maintain the $1 million bond for defendant respondents protection for any liability claims. You said that in your order.
Yes, we're very well aware of what we said in that order. Excuse me, we're very well aware. We're very well aware of what we said in that order. And the first couple of questions here were simply asking whether the landlord was getting any money. Really, that was it. Thanks. Let me hear from your opponent.
Good afternoon, Warren Estes for the respondent. The history of
Mr.
this,
Estes, let me see if I can ask you a question, and I'll try not to convolute it. But this bond was imposed on your client for a specific purpose, and the purpose was to, I'm sorry, was imposed on the plaintiff for the specific purpose of protecting the defendant from any liability claims while the merits were litigated. Isn't that right?
not exactly, Your Honor.
Oh, okay.
As Justice Sherwood's order said, the appellate division granted an interim stay, thereby enabling plaintiff to remain in possession on condition that tenant shall pay use and occupancy. As an additional condition, the court required plaintiff to maintain the bond, which expressly provides for the payment if it is finally determined plaintiff was
That
not.
use and occupancy was only for the period of the litigation of the merits. That's clear. There's no question that's what the order was. The question is, are you saying that it was for pendente lite use and occupancy? I don't think that's what you're saying.
Yes, Your Honor. What's very clear in looking at the total picture here, initially they were when the Yellowstone was denied, they were granted a stay on the condition that the bond be posted and there'd be UNO. For 3 months after your initial order, they came back to the court for clarification, for excuses why they shouldn't have to pay. It took them 3 months to finally put up the bond. This has been, and then they default subsequently in making any payments. The fact is that we were under the lease, it was found, we have an insurance requirement of $2 million. $2 million. There is no insurance. The only thing standing there to protect the building, and it's basically a standalone building, the only thing there was the bond.
So
they
counsel,
owe approximately
counsel,
$400,000.
Counsel, this is Judge Gonzalez. Counsel, hello.
Yes.
So that's where I want to go. If there is a bond that is there to provide liability coverage in case of whatever happens, then can you really use that bond for use and occupancy, which is an entirely different purpose and which fulfills an entirely different need? You don't, if the language of the decision did not specifically provide for that second use.
But if you look at they obtained the bond, you have to look at the language in which the bond was going to be paid. And if the order was affirmed, we were entitled to recover for our damages. We didn't obtain the bond. We didn't put the language in it. The plaintiff obtained the bond, and that's the language with the third party in terms of payment. It's similar to a letter of credit at times.
But counsel, I'm sorry, does it say for damages or does it say protecting from any liability claims? Says, I thought it was for liability claims as a type of insurance, as opposed to for use and occupancy or for damages. I think that's where the confusion is in my mind, because I thought it specifically said for liability claims, not for damages, not for use and occupancy that hasn't been paid.
They first of all, in their papers, they represented that the bond was there to ensure the collection of use and occupancy. When they defaulted in not making the payments, they actually put in their affirmation that the money is, the bond is there, and therefore they shouldn't have to pay for use and occupancy. That's one of the points that we covered.
Look, this is all pursuant to, I mean, really, ultimately, to the decision that was rendered from this court prior to Judge Sherwood's order.
That's correct.
Okay, so I think that's why my colleague referred to the protection for any liability claims. That's what was in the language of this court's decision. So Justice Sherwood wouldn't have been able to have something different than that flow from this decision.
But they obtained the bond, which they represented in court. In fact, the bond started on a final determination that they were not, that the tenant was not entitled to an injunction, the bond would be paid. Now, they obtained it, they used that language, and then they used it in the court to say, look, we shouldn't have to pay monthly. They're protected with the $1 million bond. Now, a bond is analogous to a letter of credit where it's between the third party and the party that's to receive it. And the fact is, on that bond, it triggered payment, as Justice Sherwood found.
So, counsel, you're arguing two sides in the sense that at the outset, you said that here is a building that doesn't have proper insurance. Here is a property that doesn't have proper insurance. And for that purpose, a bond was created, right? And then on the other hand, but wait. And then on the other hand, you say, there's money there, there's money in the bond, it should go to use and occupancy. But then you argue against yourself in the sense that the building would be left without insurance, right?
To get the stay, and they were given an opportunity in Supreme Court initially, before the Yellowstone was denied, there was $2 million in insurance. You affirmed the fact that they can't cure because they didn't have the $2 million. They asked for a stay pending the first appeal. In seeking the stay, this court said, put up $1 million bond. Not for any purpose. There was no purpose, because if anything, if you were following the contractual terms, they'd have to put up $2 million.
Thank you.
But granted a stay.
Counsel, this is.
Oh, I'm sorry. There's a question.
Sorry. Doesn't this court's January 21, 2021 order state put up the bond for defendants, respondents, protection for any liability claims? That's what this court's order says. It doesn't say for any damages occasioned by the wrongful, which it might have said, but it didn't. And because the bond itself said that doesn't change what this court ordered the bond for. That's the problem. The bond supposedly said, which will cover any damages in case the injunction was wrongfully or the stay was wrongfully issued. But that's not what this court's order said. This court order said the bond was only in case somebody put in a slip and fall for a period of time that you didn't have the insurance, right?
Yeah. No, I respectfully disagree, Your Honor.
So what do you think for defendant respondents protection for any liability claims means?
Your Honor, you have to, the issue, you have to look at literally what a third-party bonding company gave to us and what they provided that they would pay under those conditions. The appellant submitted the language to the bonding company. Now, the fact that, assuming you're correct in what you're expressing, their bonding company is bound by the terms of what they provided.
You're talking about another basis, but I understand. I think you're agreeing now that yes, the appellate division did provide this order where the bond was only supposed to be used for the liability claims. You're saying, but the bond, with a third party made a different agreement, but nobody made a motion for that. This was not, it just automatically changed from one order to another order without any motion. Practice to say, we want use and occupancy, and then failure to do that would have led to the bond coming up, because they were supposed to, the bond was supposed to ensure if the tenant didn't pay use and occupancy. But you didn't, there was no motion for pendente lite, use and occupancy.
Incumbent upon the appellant to change the language. This is the language that they agreed to give us belatedly 3 months after you ordered the money put up. And when you look at the total picture of the way the appellant has acted, they moved multiple times to re-argue your order. They moved, they said, we don't understand the clarification.
I think I understand what you're saying. Thank you. Mr. Fishman, you're muted.
Sorry. Very briefly, because I think the panel has very clearly stated the point.
We don't state anything. We try to clarify and ask questions.
Okay, well, I think the questions you've asked really show.
It seems to me, if I can just make a statement, ask a question here for clarification. The bond, what Mr. Estes is saying is that there was language in this bond where the guarantor was the guarantor if the tenant didn't pay. And the tenant stopped paying here after our order said that they were only supposed to pay for the liability claims, and they never were paying their rent. So under the language that the third party created with the bond with regard to that, they were supposed to pony up when the tenant didn't pay.
Your Honor, I disagree. The UNO was only a condition of a stay. If they didn't pay, they lose the stay. That's it. That's the remedy. Okay. And also, the language of the bond is not what's relevant here. It's the language of what this court said in ordering the bond that matters.
That's the first aspect of it, not Judge.
Right.
Not Judge.
What the appellate division said is what matters.
That's the first aspect of it.
This court said
what Judge Sherwood was doing it based on the fact that there was no use in occupancy.
Counsel, one question.
Yeah.
Is it your position that unless you're ordered, not you, but your client is ordered to pay use and occupancy, no use and occupancy must be paid?
No, we still have defenses, Your Honor, to the UNO. There are defenses that on the merits that would need to be addressed. And if there was an order to pay, then the remedy, if it's not paid, in my understanding, is that's a contempt motion. Under RPAPL 745, which applies to this case, the only remedy is an immediate trial. You don't even get to strike the pleadings like you used to prior to HSTPA. So you get a trial, and then at the trial, the defenses to the UNO claim can be heard.
Thank you very much. Thank you both. Thank you,
Judge.
Thank
you, Your Honor.
You're welcome. Edward Mollett versus 111 John Realty Corp. and 711.
Good afternoon, Your Honor.
Good afternoon.
Hi, this is Kevin McGardle. I represent defendant appellant 111 John Realty. My client is an out of possession landlord of a commercial property. There is no dispute to that.
Well, he was out of possession, but I think he had permission to come in to make repairs, electrical, plumbing, other kinds of electrical systems. He was there for access and to keep the premises in good repair, right?
My client had a right to reentry with permission from the tenant. That's correct. Yes. So
does that not then potentially render him liable for this fall that occurred with this wet substance on the ground that could have come from the area where your client was supposed to keep it in good repair?
No, it doesn't, because as an out-of-possession landlord, it's only liable for a significant structural defect or a specific statutory provision.
Yeah, but
Plus-
in your case, that went to the electrical and it went to the plumbing. And it went to, I think, other kinds of electrical systems.
Correct, Your Honor, but there is no evidence that my client created any condition. The only arguments that's on the record are from an attorney affirmations inferring that it might have happened, but the simple fact is there is zero evidence that any wet spot indeed came from piping that serviced the entire building.
Do you have anything further?
Yes, Your Honor, I'm sorry. Yes, so like I said, we don't think my client is liable for the reasons I just stated. Further, because there is no negligence, we believe that the trial court should have granted our motion for contractual indemnity against the tenant 7-Eleven. There is no dispute that we have an enforceable and valid indemnity, a contract with an indemnity provision in 111 John Realty's favor.
Counsel, I don't know, but it sounds like that request for indemnification is a little premature, isn't it? That your own building owner, the managing agent, Mr. Tesser, testified that he saw water on the floor of the mechanical room. He doesn't remember if it was before the accident or after the accident. And he also testified that he was informed by the building's engineer that there had been water on the floor. Now that, coupled with the lease provision that provides provisions, plural, that provide for access and for good repair as to plumbing and the electrical wiring referenced by my colleague, all of that leads to questions of fact that can only be determined at trial. Wouldn't you agree?
No, I don't agree, Your Honor. I appreciate your point, but any wet spot in that mechanical room, even if my client was on notice of it, and we don't concede that, but even if true,
but plumbing usually involves water, right?
Yes, that's correct. Yes, of course.
We agree there?
Yes, I'll stipulate to that, of course.
Okay. So if your person was charged with good repair as to plumbing and there's water in the mechanical room, isn't that an issue of fact that has to be resolved, or at least don't we need inquiry through discovery?
Your Honor, discovery is complete. Our witness testified that he never saw any water leak from anywhere before this accident. 7-Eleven's project manager testified that he inspected the mechanical room the morning of the incident and the afternoon and after, and never saw anything. There is testimony that my client's managing agent indeed saw water at some point, but he did not know when. It was before or after. And just whether if there is water, to clean it up is indeed the duty. It was transferred by contract to 7-Eleven.
But we also have the plaintiff who testified that there was water on the floor when he went in to inspect. So again, why does that not establish a question of fact where we have competing statements as to the presence of the water on the floor and the responsibility of your client based upon the lease as to notice of leaks and plumbing on the premises?
Well, in terms of my client with notice, this court in the Devlin case ruled that for an out-of-possession landlord, even if they were on notice of a condition, are still not liable because the maintenance responsibility for that property was indeed transferred to 7-Eleven.
Wouldn't you agree that the maintenance responsibility is shared? That's what the lease says. You have Article 8 of the lease, and you have that talks about the landlord's responsibilities, and then you have Article 8C of the lease that refers to the tenant's responsibilities, and they both have repair obligations.
Your Honor, I would refer you to the testimony for the parties, even 7-Eleven's project manager witness conceded that it was their responsibility to maintain all the basement area and the mechanical area, that all the equipment in that area was indeed installed by 7-Eleven for their sole use. The building owner had nothing to do with this basement. They did have a right to re-entry, but only with permission from the tenant, and did not have any maintenance responsibility for that area.
Thank you. Let's hear from the respondents.
Wait.
Hello?
May it please the court. My name is Nicole McCord and I represent 7-Eleven in this matter. We're the appellant respondent. It is our position that 7-Eleven affirmatively established that it lacked actual or constructive notice of any wetness on the floor of the mechanical room floor. The courts have held that.
I think it was Mr. Romer for 7-Eleven that wasn't able to talk about when he came in to do any sort of the mopping or cleaning or anything else. So isn't there a question of fact on this record, at least, with regard to whether or not they properly cleaned or were aware?
No, because Mr. Romer testified as to his multiple inspections prior, the day prior, during the day of the accident, and after the accident of the mechanical room. You know, he performed an all-encompassing.
What records? What did he base that on?
His memory.
Right, exactly.
This was
he has no records or anything else to establish that. No cleaning record that where there's a particular time each day. Nothing like that.
No, this was a basement. This was a basement mechanical room, and this was the day prior to a grand opening. So the store was not technically open yet. He was doing all the pre-inspections that needed to be done. So because of
yes. May I ask you, do you agree with the owner, with John Realty, that John Realty had no responsibility for the pipes in the mechanical room?
No, I don't agree with him. I think that there were existing pipes in the mechanical room that serviced the entire building. So if there was any
pipes were water pipes, correct?
And sanitation lines.
So there was no affidavit from someone from John Realty saying, I inspected those pipes the day of the accident and they weren't leaking. There was nothing.
No, but we do have Eric Romer, who testified that he did inspect all the equipment in the mechanical room and found that nothing was leaking. There was no malfunctioning of any equipment. He also testified that if there was any leaking or any condensation created by any of the equipment, that there would be a complete shutdown of the equipment.
Except that Mr. Romer, as I just said, given his testimony, didn't state anything about the time, or he didn't start a record. I understand that the place was just going to open, but the fact is, you just told me he went in the day before, he went in the morning, went in the evening. Well, then at some point you need to establish it, and he could have established it from the moment he first went in. But based on this record, I guess the question is, does his inspection that you've just talked about eliminate the condition that existed for a sufficient length of time for the defendant to have discovered it and cleaned it?
Well, I think it does, because the courts have held that the defendant meets its burden to establish the lack of constructive notice by offering some evidence of when the area was last inspected.
Exactly. The some evidence has to be reliable.
Well, he did testify that he performed his inspection that morning.
Okay, and that early in the morning, he only said early in the morning. He wasn't really sure about what time or prior to the incident. No records whatsoever concerning the cleaning, when it was last cleaned, when it was last inspected. This was all based totally upon his memory.
His memory, correct. It was more of a routine, I think, that he made two inspections of the mechanical room and its equipment, one in the morning and one in the afternoon, and that is what he did last.
This is Judge Scarpula. Isn't that testimony, his testimony, Mr. Romer's testimony, that he never saw any leaks in the basement, contradicted by Mr. Tesser's testimony, who said he did see a leak in the basement, right?
No, because
So
we don't.
Romer says, I go in twice a day, I never saw any leak. Tester goes in and testifies, oh yeah, there was a leak in the basement. And then the
plaintiff slipped on water in the basement.
Well, where plaintiff fell was in the mechanical room. There are other areas of the basement other than the mechanical room. I don't know where Mr.
But he said that, I think he slipped on the stairs, I thought. But he was in the mechanical room.
I'm sorry, I don't think Mr. Tesser indicated that he specifically saw it in the mechanical room as opposed to another area of the basement.
Actually, he said he did testify that he saw water on the floor of the mechanical room, and also that he was informed by the building's engineer that there was water on the floor. So aren't those issues of fact that have to be resolved at trial?
Obvious conflicts in the testimony in terms of what occurred, when it occurred, etc. So why would you be able to grant summary judgment on that record where there's an obvious conflict in the testimony?
Well, I think that Mr. Tesser's testimony doesn't establish when he saw this water. Mr. Romer
neither does Mr. Romer's testimony, right?
He was there that morning and again after.
Thank you. You have rebuttal because of the cross claim, the cross appeal. So why don't we get to Mr. Crenini? Is that it?
Prentice.
Sorry.
So I just have a brief point to make, and I will rely on my submissions.
Okay.
I will remind the court that by Mr. Romer's own testimony, he said he was gone for 8 hours from the accident site on the day of the accident. So theoretically, the wet condition on the floor that caused the accident could have been there at least 8 hours. And I can cite 100 cases easily that says that 8 hours is more than enough time to grant, to impute constructive notice on the defendants. This is indisputable. Mr. Romer is very vague about when he was there and when he wasn't. He doesn't even give specific times. He gives generalities like early morning, late afternoon. He theoretically could have conducted his inspection at sunup, 5 or 5:30 in the morning. We don't know that. His testimony is too vague to grant summary judgment and take away the plaintiff's right to a trial. Anyway, I think that's all I need to say, and I will rely on the oral arguments that preceded me and my submission.
Thank you, sir. We're back to you, Mr. McArdle.
McArdle, yes. Okay. Just very briefly, Your Honor, I just would like to emphasize again that we have been deemed an out-of-possession landlord. There is no dispute. The motion court found that. And indeed, all maintenance responsibility was transferred to 7-Eleven, and this accident happened within their demised premises. That is not in dispute here. For that reason, we also believe that our motion for contractual and common law indemnification should be granted against 7-Eleven.
Thank you. And Ms. McCord?
Yes, I'd like to also bring up the argument also that we made that was completely ignored by the court was our argument on proximate cause. This court in Salgado versus New York City Department of Education held that without a specific allegation as to what precipitated the fall, a claim for negligence is based purely on speculation. And I feel that this is what we have here. After plaintiff stepped in the moisture and completed his inspection, he then walked to the stairs. He didn't observe any tracks of wetness. He didn't feel any wetness under his feet. He didn't have any difficulty walking.
Well, what he meant was there was no pool of water under his feet, that kind of wetness. He referred to the moisture that was on the floor, and he said his foot slipped. And he says the foot slipped because of the moisture that he felt in the mechanical room. So there's the proximate cause. He's not saying I'm not sure what it was.
He didn't see any moisture on his shoes after the accident. He didn't see any moisture on the stairs after the accident. Plus, I think it's extremely telling that he gave numerous accounts of how the accident happened shortly after the accident that were completely different and that were contradictory to any moisture that was on the floor. In one report, he indicated that he was injured while using a ladder. In another report, he said that he partially tripped. None of these incidences have anything to do with water or moisture on the floor, and plaintiff doesn't even attempt to acknowledge these different conflicting reports or to rectify them.
Thank you. Thank you, all three of you.
Thank you.
Have a good
Thank you.
afternoon.
Thank you.
People versus Albert Vega.
Good afternoon, Your Honors. Harold Ferguson for Appellant Albert Vega. No one disputes just how horrific the actions of my client in this case were. But the real issue here is whether this court should apply People versus Watt to Mr. Vega's situation. And I believe that Mr. Vega's situation is even more sympathetic than that was presented in the Watt case. Here, my client clearly has lived an absolutely horrible life, suffering traumatic physical abuse as a child. He has serious mental health issues, serious substance abuse issues, and they've only exacerbated over time. He tries, and he tried after he was released from prison, a place where his condition deteriorated because of the failure to properly medicate him while he was incarcerated, so that his condition had deteriorated while he was in prison. And when he got out, he was placed in a situation that was not the most beneficial position for him. Someone with serious mental health issues, someone with substance abuse issues, placed in a shelter system is almost designed to fail. And here, my client on two separate occasions recognized that with the theft of his medication, his mental health was deteriorating. He went to a hospital, asked to be admitted so that he could, have his illness treated.
Counsel,
and the hospital.
how do you balance the plea bargain? 14 years, he was sentenced to 14 years as promised because he pled to the top count, right? How do you balance that with the fact that he was facing consecutive sentences because of the separate attacks on two separate individuals, with the resulting 50-year exposure? How do you, given the, if you weigh those in light of what he is charged with and what he pled guilty to, where do you end up?
I think we end up in that is the exact same situation that was present in Watt, that it was two separate violent incidents, and that individual was also facing 50 years, consecutive 25-year sentences in that case. He also plea bargained to a single concurrent 14-year sentence. And I think that using the precedent of Watt in a situation where, unlike in Watt, my client tried on several occasions to get help, and instead he was turned away from the hospital. He understood that he needs his medications, but with them stolen and the paperwork stolen while he was in the shelter system, when he went back the second time, all the hospital gave him was a new prescription. He has no resources. He's dependent on Medicaid. Medicaid, the pharmacies recognized that he had previously, re-upped his prescriptions. He could not get them, and his condition just continued to deteriorate.
But you are talking in the context of a first incident which occurs 3 days before the second incident, right?
Absolutely.
So there's no, for example, attempt to go to a hospital after the first incident. There's no cry for help after the first incident.
No, but what you have is that on two occasions before the first incident, he goes to the hospital, was denied entry into the hospital, and what he turns to is what he had turned to in the past, which was illicit drugs. And those just exacerbate his problems, makes him more delusional. And when he commits the second incident and is arrested, he again is expressing suicidal ideations. This is an individual who needs tremendous treatment. And looking at what occurred to him on this previous stay in prison, where his condition was not treated properly by the authorities, one can see that his condition is going to deteriorate again. And again,
what do you suggest we do here, Mr. Ferguson?
I would ask that this court do exactly what it did in Watt, and to reduce the sentence from 14 to 10 years, which is what this court did in Watt, which was the minimum sentence that was available here. It is still a lengthy sentence. He will still be subject to post-release supervision after he is released. And we believe that the minimum would be appropriate here, and that's what we would ask this court to do. I understand that what my client did is not excusable. It is horrific. The innocent victims suffered greatly as a result of his actions, but we're asking for this court's leniency to recognize that, if you look at this in the terms of maybe judicial expediency, that we could, if this court denied it, seek resentencing under the Domestic Violence Act, because the psychiatrist indicated that his traumatic childhood was never treated. So we would ask this court to perhaps consider that.
But there's no domestic violence here.
But it is domestic violence includes here the type of physical abuse that he suffered at the hands of his family, including his mother, who beat him viciously, and the psychiatrist indicating that this is part of what led to his present condition. That these are situations
in the face of a victim.
Again, Your Honor. Again, no one can downplay how serious of what he did here. All we're asking for is a level of leniency that was shown in Watt. And in fact, in that case, it was an attempted murder that the person was convicted of. As bad as what my client did here, I would say that Your Honors would all concur that attempted murder would be worse than an assault conviction. And
Thanks,
so we
Mr.
ask this
Ferguson.
court to
You have some rebuttal.
Thank you, Your Honor.
Mr. McLaughlin? What is it?
May it please the court. Good afternoon. Yes, Your Honor. My name is Megan McLaughlin on behalf of the people. Now, the defendant in this case approached two separate people on two separate occasions, 3 days apart.
So, counsel, I want you to get right to the issue that Mr. McLaughlin is speaking about, because he admits that he acknowledges there's no question that this was horrific. These people got slashed, awful. But he's talking about whether 10 years is, I guess, as appropriate or more appropriate than 14 years. 10 years is an awful lot of time. And in 10 years, whatever psychiatric improvement the defendant would have, hopefully would happen. Certainly 4 years additional wouldn't change that. And he has, as Mr. Ferguson indicates, he's had a very hard childhood, but more disturbing is that he goes to the hospital and is turned away. He goes to the psychiatric hospital and is turned away. So what is a defendant, just looking at the circumstances of how we finally get to this point where this person who has sought psychiatric assistance, has tried to get the medication, but can't, and then finally devolves into this awful situation where he slashes. Is this a case that, as in People versus Watt, is deserving of a reduction?
No, Your Honor. And a few things to that is, first of all, in regard to his mental health, this defendant was able to get his medication after he went to the hospital initially. The defense's psychological evaluation says that he misplaced his own medication, and then it is true he was not able to get it a second time. But in this evaluation was done prior to his sentencing. It was actually explicitly done in order for the sentence to reflect his mental health problems. And it was in front of the sentencing court. And as this court has pointed out already here, this may very well have been a reason why, when facing 50 years, the sentencing court chose to only give this defendant 14 years, chose not to sentence him consecutively despite 2 separate victims and 2 separate occasions. Now, in reference to People versus Watt, this defendant's situation differs in 2 very significant ways from the defendant in People versus Watt. Now, first, the defendant in, well, 3 significant ways. The defendant in Watt was 19 years old. This defendant was 29 years old. Now, this court mentioned a few times in Watt how peer pressure was likely a very significant aspect of the defendant in Watt and his crime. Here, there was no peer pressure that could have possibly been involved. This defendant approached 2 people of his own volition and slashed them in the face on 2 separate occasions. And another aspect of this court's decision in Watt was that the defendant in Watt had very little inclination toward committing crime before the crime for which he was convicted, where he was likely pressured by his co-defendants. Here, this defendant has significant criminal history, significant violent history. This defendant committed these crimes just within 3 months after he was released from prison on his first-degree robbery conviction, and that was after committing 2 violent crimes, 2 violent felonies in Florida where he lived previously. So this defendant's situation is completely different than the defendant in Watt, who was a young person who had barely committed any crimes and was pressured by his co-defendants, whereas here we have somebody who has a very violent history, was 29 years old, had access to his medication, misplaced his medication, and proceeded to commit a very violent crime on his own. And for those reasons, his mental health, despite him having mental health problems, they were taken into account with regard to this sentence and his history.
Thank you. Mr. Ferguson, we're back to you for a minute.
Just to say that it was more that he didn't simply ask for help at the psychiatric hospital. He asked to be admitted and institutionalized. He recognized what the trajectory was going to be, and the system failed him. His parole officer failed him. And again, as someone who's well past 29, to say that 29 is significantly older, I mean, he was still a young man at the time of this event, at the time of these events. And I think that under the totality of the circumstances, and when you add in the fact that he sought help and the degree of the trauma of his childhood and his entire life history, makes him a more sympathetic person than the individual this court granted leniency to in Watt. And so we ask this court in the interest of justice to reduce his sentence. Thank you, Your Honors. Have a great day.
Thank you. Thank you. You too. Thank you both.
Thank you.
New York City asbestos litigation versus RC International.
Good afternoon, Your Honors. This is Jeffrey Fegan for the defendant, appellant Mario and DeBono Plastering Company. The issue that I wanted to speak about this afternoon, if I may begin, is why Mario and DeBono's installation of sprayed fireproofing at the World Trade Center in 1969 and 1970 did not launch a force of harm that injured the plaintiff decedent Arthur Shanahan in 1986, when for a period of 1 to 2 days, he appeared and removed the sprayed fireproofing from the building's beams and claims that...
Wasn't it 4 days, counsel?
I apologize, Judge. It may have been 4 days, less than a week. I will say for a period of less than a week, I think everyone can agree that he was working at the World Trade Center. That's the only time he ever worked at the World Trade Center in his life, and says that that caused him to develop lung cancer another decade or so, even after that. Mario and DeBono, as the record showed, installed this product pursuant to a contract. They did not leave a dangerous condition when they left. in 1970, 71, more than a decade before Mr. Shanahan arrived.
So, counsel, may I just ask you some background questions? I don't believe the full contract is in the record, so we don't know if I'm going to call M&D, if you don't mind. If they helped choose the product, and the product was a little controversial, wasn't it? Didn't U.S. Mineral, the supplier, indicate that it was hazardous and marked as such? And didn't U.S. Mineral also indicate that that M&D had the option of using a non-asbestos option, but decided not to use it because it wasn't as efficient, I guess, as the asbestos product? Don't these issues come into play in creating a tribal issue of fact as to liability?
No, I would say no, they don't, Judge. Partially, I could speak for a very long time about what happened in 1968 and 69 when they were bidding on that contract. As you said, it's not in the record. We got an incomplete contract. The contract, what you have before you, only says that Mario and DeBono was supposed to use a product manufactured by another company and install it and leave. There's really nothing at all in the record that indicates they did anything but that.
Could you clarify when you say you got an incomplete contract? Who's we? You mean
Your Honors got an incomplete contract, and Judge Mendez below got an incomplete contract, which was only attached in opposition to our papers. The contract itself is roughly 200 to 300 pages long. I think you may have gotten about 50 pages of it.
Counsel,
I can, if you want, it's not in the record. I would know. I've been representing for 15 years, but I don't know how you'd like me to address that.
I have a different question, I guess. I'm wondering, as it's your summary judgment motion, and as the proponent of the summary judgment motion in an asbestos case, don't you have the burden of showing that the fireproofing that your client is alleged to have put in there could not have contributed to the plaintiff's cancer? And has that been, or illness, and has that been ruled out, given the testimony that we have from this person who would have been in a position to know, Verhalen, if I might be getting his name wrong, but wouldn't he have been in a position to know? And he says specifically that they could have chosen something else, as my colleague said, but they chose this because it was more effective.
Here's what I would say the issue is with respect to my prima facie burden, Judge. I have a prima facie burden to show there's no issue of fact based on the pleadings that I get. The pleadings, the argument that we're having here is not something that was contained in the pleadings that I got. They only made that argument in opposition to my motion. The motion was based on several cases that this court has decided in which product manufacturers who actually did create and sell products and put them in the stream of commerce had products at the specific locations where the plaintiff claimed to have been exposed to that type of product. They just didn't name their product, and that was a prima facie showing.
This is Judge Scarpula. Didn't the plaintiff name your company in its interrogatories?
No. They did not.
You're saying in response to the interrogatories, your plaintiff didn't say that he was subject to asbestos, including you.
He did not. He was specifically asked what products and what contractors contributed to your exposure to asbestos, and my client was not listed.
Okay, because I thought I had seen in the record that in his answer to an interrogatory, he did list your client. So maybe that's wrong. So how did you think that you were here?
I thought that I was here because when the plaintiff would sue us, that he was present while we, the non-manufacturer of this product, applied it in a negligent manner, i.e. I was standing 50 feet away from Mario DeBono. They didn't tell me to get out of there. They didn't put up a tarp. They didn't try to wet it down. They just sprayed me. That's not what he said. He wasn't there. He mentioned in his deposition that I knew in 1986 that Mario and DeBono may have preceded me at the World Trade Center over a decade ago. Wasn't necessarily founded on personal knowledge. I'm not denying that we were there. They were, but he wasn't there. And that any condition that they may have created in 1971 did not hang around until 1986.
I'm sorry, I misspoke. You were correct. Didn't he testify in his deposition? That's where I saw it. In his deposition, he said, I went in and took off this asbestos that M&D put on, correct?
That is correct.
So there's no surprise to you that he knows that you're the one who put that on. He's pulling it down and the dust is coming up. It's your asbestos. You're the company, it's not your asbestos. You're the company that put the asbestos up, correct? So this is not a shock or a surprise to you. So then your burden, as Judge Renwick said, is to show that you couldn't have caused his
illness.
Or I guess he has lung cancer, right? So what did you put in to show that you could not have caused his illness?
I put in the record showing that Mario and DeBono's actions could not have caused not his illness, Judge, but his exposure. Their actions were to install a product that they did not make, and he misused a product that they were not in control of the environment of more than a decade later.
How did you show that? What did you put in to show that?
His testimony, where he said, I was at the World Trade Center in 1986, and when I removed this product, I know Mario and DeBono did not make it. He named the manufacturer. Another company made it. I was there. It was not dusty, and I took a hammer to it, created dust in this work site that was not run by Mario and DeBono. They didn't even know he was there. They're long gone at that point, and said that I myself created this condition at this site where Mario and DeBono did not have a continuing obligation to maintain or even warn. It's not their product. And I caused this. So what I put in is the interrogatories, the pleadings, where there was no such allegation that a force of harm argument would be argued against me. I could have addressed that if they did that, and the record would have been different. And I put in his testimony where he said they didn't make it.
So let me ask you, it's your position that there's the testimony that said that your company could have chosen, you knew the risks of that asbestos, but you put it up anyway, even though you knew or you had knowledge that it was a problem. That doesn't create an issue of fact?
No, the record that was partially put in, I think, Judge, if you look at it, the so-called warning that they were talking about was not a warning by the product's manufacturer, United States Mineral Products, but a caution statement that related to people who were applying the product, that if when Mario and DeBono's workers themselves were spraying this product all day, every day, for a career's worth of time, that they might be in danger. It wasn't a warning. It did not say cancer. It did not say harm. It just said, be careful if you are applying it. And it wasn't their product. Again, it was there to deal with the people who were applying it and then cleaning the mess after it's applied in the immediate aftermath of that action.
So
which Mr. Shanahan was not
about
present.
Brett Hamlin's testimony that you knew of the dangers and risks associated with dried asbestos and you put it up anyway? That's the testimony. You might disagree with it, and certainly a fact finder might disagree with it, but that's the testimony in the record, correct?
I don't agree that that is the testimony in the record.
Oh,
the testimony in the record is, for one, very incomplete, but two, the trial that it was used from 1995 was a trial where Mario DeBono was present while the plaintiff said this was occurring. That was what the testimony was about. It was not about product liability, which this case is not. And the plaintiff respondent does not even allege that. This is only about whether the act of putting this material in was negligent to the effect that more than a decade later, someone could turn it into dust, which is what happened. And our argument is that it just simply can't be. It's too far.
Thank you. Let's hear from your opposing counsel, Mr. Weinstein.
Good afternoon. Jason Weinstein for respondent plaintiff. Your Honors, defense counsel repeatedly talks about and labels the record as incomplete, yet this was the defendant's appeal. The defendant, in moving for summary judgment, did not move on a theory that one of the Espinel exceptions did not apply. And so to the extent that defendant now claims that only part of the contract was in the record, that's because plaintiff put part of the contract in the record, and specifically for the purpose to show that Mario and DeBono did spray the product at the World Trade Center. Now, it was on defendant if defendant was going to raise this type of defense, which was never raised below. It's now dehors the record on appeal because the defendant never put it into the record in the summary judgment motion. And in fact, even in the reply papers on the summary judgment motion, once we said that the defendant had raised a force of harm under Espinel, the argument by the defendant then was not that the defendant merely acted according to the obligations of the contract and then put in the contract as an exhibit, but they argued that Mario and DeBono did not launch a force of harm. There was nothing in their reply papers before Justice Mendez.
I thought that they were arguing that they were not required to negate any of the exceptions in Espinal because you, plaintiff, had not specifically alleged that any exception applied. Had not specifically alleged that any exception applied, so therefore they were not required to negate any exception.
Quite honestly, Your Honor, that's a baffling argument because I don't understand either where there is any obligation for plaintiff to specifically do that. And it was quite apparent, given the time and place of when Mr. Shanahan was exposed to the defendant's product in the World Trade Center. There's no question, as Mario and DeBono states, their work was done well before 1986 when he was there. And he specifically talks about how he was exposed. So there's no question in the defendant's mind exactly how Mr. Shanahan was exposed. And even looking at the...
Well, he's saying they didn't launch anything, I guess is going to be his argument, because it was just there sitting on the wall, not harming anyone until plaintiff took a hammer to it.
Right, because they're claiming that they were merely...
not harming anyone. But it was the distribution of it by hammering into it that launched it.
And if anything, that they were merely the contractors, and that was it, and they had no further involvement.
And if anything, Your Honors, that's a contributory negligence argument that the defendant can make at trial. And in fact, defendant in their papers accused Mr. Shanahan of operating in violation of OSHA standards. But again, that's dehors the record. There's no exhibit to that effect. Defendant has simply not made an adequate record on this appeal to mount the type of defense and the type of appeal that they now do before this court. There's no full record of the contract because they never put it in as an exhibit. There's no exhibit to support that Mr. Shanahan operated in anything except a foreseeable way. This was one of the two twin towers. This was a massive office building. He was simply reframing a vacant floor for a new office configuration, which is a fully foreseeable action. He was a trained professional, and he was exposed to the dangerous product that the defendant, which had a strong hand in choosing this specific dangerous product, left in the building, and which could expose workers such as Mr. Shanahan for decades to come.
Thank you. We're back to you, Mr. Fegan.
Fegan, yes, Judge. Very briefly, this is not an issue of foreseeability. It's an issue of duty. And if my client had been put on notice that they were alleging a continuing duty related to negligence in their pleadings, I would have addressed Espinal head on. That is the law. If they don't bring that forth, and that's the case law that we've cited in the brief, if they don't put me on notice that this is what they're claiming during discovery, so I have a chance to refute it and make it part of the record, I'm not under an obligation to refute it when it hasn't been raised. That's why this record is incomplete. If they made the claim against me, you'd be looking at a much different record. The claim that they made against me was based on negligence. I was there or I wasn't there. And is there identification of your client, which is why we cited the cases of Schiraldi and Comeau. And it's simply not there. So that's the only reason we're dealing with this kind of a record. It has nothing to do with Mario and DeBono because we're not under an obligation to refute something that they did not plead. Thank you.
Thank you. Thank you both. Kurovuskaya versus Project OHR.
Good afternoon, Your Honors. May it please the court, Kevin O'Connor on behalf of the appellant. Project OHR has for decades served the indigent, the poor, the disabled as a home health care provider. The court below improperly certified a class of home health aides, home health care assistants, I should say, over an extensive period of time on an inadequate record. And I submit to Your Honors that when the Court of Appeals indicated that such cases could be considered for class certification, and that was in 2019, this was not the type of case that they had in mind.
Why not?
Well,
the court said that class certification should be liberally construed. It seems that they have a number of overlapping issues. Why shouldn't this case, like I think it was another case I can't quite pronounce, the Andreeva case, where there are common questions of law and fact regarding the issues?
Your Honor, excellent question. And if you look at Andreeva, 14 employees put in highly detailed affidavits, and the court did a painstaking analysis of the 901 and 902 requirements. Here, what do you have? Look at the affidavit of Ms. Karovskaya and then compare that to her deposition. In her deposition, she admitted this is 241 of the record and 242, that she didn't work live-in shifts. She didn't work live-in shifts. What the plaintiff has done is confused the court below by kept saying, well, she worked 24 hours in a row, not explaining to the court that what she did was she worked 2 12-hour shifts. These are certified home health aides, certified by the state of New York. Home health aides work either 12-hour shifts or 24-hour shifts. And some of them work less than 9 or, they may work 9 or 4 hours. But what we're talking about here are live-in shifts, live-in folks who go in at 8 a.m. one day and they leave 8 a.m. the next day.
I saw that argument in your papers, counsel, but we're talking about the wages that were paid. And I know you make much of the fact that some were live-in, some were not live-in. I think you said the males tend to, there are fewer males, and so that they would be more prone to have these assignments where they were living. But what we're talking about is the wages that were not properly paid based upon the hours that they were actually working, also in terms of the improper breaks and also meal breaks. So why would that be not enough in order to establish the class?
Well, the two named plaintiffs would have to establish with competent evidence, and this court has said it has to be competent evidence in an affidavit form. They have to prove that there was a common policy or plan that violated the labor law. Ms. Karovskaya did not work live-in shifts. It's just in her deposition, 241, 242. She didn't. Mr. Domnich, we deposed him. He didn't put in an affidavit at all. He testified, he acknowledged that he was trained. He acknowledged he knew he should complain if he didn't get adequate sleep. He acknowledged he never complained to the employer. And respectfully, if this court approves such a low threshold for class certification, it will be devastating for employers. The burden of a class action based upon flimsy evidence. Ms. Karovskaya, again, never worked live-ins. They admit this in their brief. She worked 2 12-hour shifts back to back because she accepted a 12-hour shift from a colleague and then decided that she would work 2 12-hour shifts. For the motion. And so your Honor's question is an excellent one.
You froze. I'm sorry, Mr. O'Connor, you had froze for a few seconds, so I'm not really sure what you were saying.
Okay, I'm sorry, Your Honor. So Mr. Domnich, again, didn't put in an affidavit. His testimony was very clear. He was trained and he didn't complain. There's an unrebutted affidavit of the executive director of OHR. There was a policy and practice of training folks several times a year. This is city work that my client was doing, for the most part, HRA contracts. This is city money we're talking about. They were trained. They were told how to complain. They were told that they're entitled to sleep and meal breaks, and there's a procedure for them. There's a 1-800 number. They didn't use it, and there's no evidence that they did. And the plaintiff never took the deposition of OHR. I mean, this is not, respectfully, not the type of case. This will be the first opinion after Andreeva where this court will weigh in on what is needed to certify a class. And respectfully, this is not the right record. If you look at what the second department did recently in Marino, they denied it. A very similar fact pattern where you had plaintiffs with conclusory affidavits and no real record developed. And the Marino court, when it was remanded from the Court of Appeals, the Marino court and the second department denied class certification. Your Honor was right. There have been a number of cases certified for class treatment. Andreeva, 14 affidavits, highly detailed. Bernarez, 5 affidavits from current and former employees, highly detailed. Zuparov.
Counsel, this is Counsel. Didn't these plaintiffs put in pay stubs? All I mean, we're not, they put in affidavits, they were deposed, they put in pay stubs, they put in your policy manuals, and they all said the same thing. I mean, I don't understand, what do you mean by this is all conclusory? They showed how much they were paid, they showed how many hours they worked, they said they were not given this. How is that conclusory? And even if so, these are all trial issues. The question is, are there common issues of law and fact? And is the class big enough that this makes more sense than having every single plaintiff come forward?
Well, Your Honor, excellent question. So if you look at the 901, 902 factors, there's a whole range, as we all know, of what has to be satisfied. And they did provide pay stubs, but they have to show, and Andreeva, the Court of Appeals was clear, that if an employer has a policy of not following the labor law, let's say, for instance, you had a case where an employer said, I don't care if you don't get any sleep, I'm not going to pay you. I'm not going to pay you. You can complain all you want. If there was evidence of that in the record, then there would be a class certified. And if that class was large enough, right? Here, there is no such evidence. You have 2 people, one of whom didn't work live-in shifts, the second of whom didn't even give you an affidavit, and who acknowledged he was trained on a procedure and acknowledged that he never told the employer he wasn't. So if you look back at the definition of having to pay someone wages or overtime, they have to be basically made to suffer or permitted to work. So how is an employer liable for someone who works through a sleep break if the employee doesn't follow a procedure they were told about, doesn't even tell the employer? So think about respectfully.
So counsel, don't we have what did Mr. Domenech say, that he slept on chairs during 24-hour shifts, that there was no place to lay down, that your manual talks about, your policy talks about having 2 people work the split shifts, but here you have people working 24-hour shifts. They're supposed to get at least 5 hours of uninterrupted sleep. And you have his allegations that nope, he was interrupted because his, I'm going to call it a client, a patient, was very, very needy, medically needy, dementia, and so on and so forth. So you have a whole lot of people in this category. Your own manual says that you have over 1,500 employees, and you have people in 2 categories, the split shifts and the 24-hour shifts. This issue before us is about class certification. So why don't we talk about that issue?
I'm going to ask that you answer that question on rebuttal. Let's go to Ms. Lucia, but please remember that question, okay? Ms. Lucia?
Good afternoon, Your Honors. It's absolutely right, Judge Gonzalez. This is all about class certification. And the plaintiffs here submitted sufficient evidence meeting the burden that they needed to under 901 and 902. It's absolutely incorrect that plaintiff Kurovskaya did not work live-in shifts. She actually did work live-in shifts, and the record on page 60 shows where the defendant paid her a flat rate for working a 24-hour shift, which is one of the allegations, the common allegations that plaintiffs make here. The defendants are ignoring the evidence is what they're doing. They're ignoring their own records. They're ignoring their own admissions that they pay a flat per diem rate for every 24-hour live-in shift. They do not keep track of the actual hours the plaintiffs worked. They do not keep track of any meal and sleep breaks that the plaintiffs are required to receive. And they do not.
Let me just ask you, though, just for clarification of something you said. Are you saying that this is only for plaintiffs who have had 24-hour shifts?
Well, no, Your Honor.
Only for round-the-clock 8 to 8 shifts?
Well, some of the allegations, when you talk about 24-hour claims, you're talking about that these individuals were paid a flat rate shift. If you have also hourly employees. The plaintiffs together all allege that they weren't properly paid, and that allegation is common.
I just want you to clarify that point. Are we talking about somebody who goes in at 8 o'clock and 8 a.m. and doesn't leave until 8 a.m. the next day? Or are some of these plaintiffs in a different position? Not that case.
Some of the plaintiffs are in a different position.
And what position is that?
Some of the plaintiffs are what we would call hourly workers. So they work shifts that are fewer than 24 hours.
12-hour shifts, for example.
They may also work 8-hour shifts. They may also work 10-hour shifts. They just don't work a live-in shift. But those individuals are also part of the class, as Justice Kotler correctly ruled, because they also have claims for unpaid overtime compensation. They have claims for unpaid spread of hours compensation if they work 10 or more hours in a day.
So as was articulated earlier, or I won't say articulated, but asked by a colleague, this all goes to the wages and the meals and the benefits, I guess, of what they are supposed to be paid. Is that correct?
Absolutely. I believe it was Justice Weber that pointed that out, and that's absolutely true. They all allege the same thing. We weren't paid correctly. We didn't get the correct amount of benefits. We may have worked different shifts. However, that all goes to damages. And this court, the Court of Appeals, the Second Department, all of those courts have said that differences in damages do not preclude class certification. The Court of Appeals in Andreyeva recognized that these exact same claims that the plaintiffs bring here are perfectly suitable for class certification. And they are common claims that are alleged. And while the Court of Appeals didn't pass on the merits of the class certification decision, it recognized that Article 9 is to be liberally construed and that there are claims that are more efficiently resolved in a class certification context, like the claims that are brought here. The individual class members here, whether they worked 24-hour shifts or whether they worked shifts that were fewer than 24 hours, all allege they weren't paid by the defendant, and they all allege they didn't receive the correct supplemental benefits under the Wage Parity Act and the Living Wage Law. That's across the board. So Justice Kotler was correct in recognizing that 901 and 902 was satisfied. As far as the evidence goes, there are affidavits that were submitted. Kurovskaya, again, she submitted an affidavit and her deposition testimony. There's no rule that says that Plaintiff Dominic had to submit an affidavit. He submitted his deposition testimony. That's evidence that's before the court. It was before Justice Kotler when she made the decision to grant class certification. Both individuals worked live-in shifts. Now, Dominic worked more live-in shifts than Kurovskaya, but even if, for argument's sake, let's say Kurovskaya never did work a live-in shift, doesn't mean she's not an adequate representative. She's representing the other class members on all the other claims for unpaid wages. She still wasn't paid correctly. But as I said on page 60 of the record, there's evidence showing she was paid a flat shift rate. The defendants didn't even meet what's called the 13-hour rule here. They didn't even pay 13 hours minimum for the 24-hour shift. They only paid 12. Now, they paid a differential for working a 24-hour shift, but that's not counted as an hourly wage. So that's also a common claim of unpaid minimum wages. And as far as the second,
if you'll just wrap up your point there.
Okay, one last thing is I just want to point out that the Second Department's decision in Moreno is distinguishable because there the plaintiffs did not allege that they did not receive the sleep and meal breaks, which is unlike this case where the plaintiffs do allege they didn't receive them.
Thank you. Mr. O'Connor?
Thank you, Your Honor. She said a lot there, and I'll do my best to quickly respond. But to get back to the question that was posed, that it's all about class certification, right? We have a broad class that's been defined here as everybody who's worked for this employer over the course of how many years? An enormous amount of time. There is not a sufficient record. We're counsel in the Marino case, and I'm well aware of the allegations that were made there and why that class failed. That class failed for the same reasons that this class should fail. Ms. Karovskaya admitted on page 241 that she didn't work live-in shifts. So that leaves you with some alleged violation that might exist in the payment of her wages.
But we're talking about, I mean, so that there's clarity, I think it's been said a number of times now. We're talking about their wages, their benefits, their all of those things, right, that are not consistent with what they should be. And not that it has to be 24 hours, but that it's some variation, whether it was 12 hours or 10 hours or whatever it is. Still, the class representatives failed to receive the benefits that they were supposed to receive pursuant to whatever, whether it was 10 hours or 12 hours or 24 hours, whatever it was they were supposed to receive under those circumstances.
No, I understand.
Do you agree with that? Do you agree with that or not?
I believe that the court's order and the scope of this class is so broad that it's not clearly defined. So if we respectfully would submit that this case should be remanded so that the court could look at that and give a specific class that has been defined. Where are the violations? So I will get to the court's decision says that plaintiffs do not have to have evidence of a common policy or plan applied to the putative class. That is directly contrary to this court's holding in multiple cases and the Court of Appeals holding. There has to be a common unlawful policy or plan that was applied, and there's no finding of that here, Your Honors. So respectfully, all right, thank you.
I think we understand what you were going to, how you were going to get in your sentence. Thank you both.
Bye-bye.
Thank you.
Bye-bye. Have a good afternoon. Turner Construction versus Mount Auburn.
Good afternoon, Your Honors. My name is Stephen Kaplan from Kaplan Levinson. May it please the court. Does everyone hear me okay?
Yes, we hear you fine.
Okay, thanks. Your Honors, I think it would be helpful and important to set the procedural table for what happened in the lower court. This matter was commenced by the filing of a statement of claim in the AAA in an arbitration case under the construction rules. The statement of claim is found at the record page 118 as a fairly detailed instrument that goes into a set of detail about a calculated effort to conceal the substitution and omission of construction materials in a multifamily development near Albany, New York. That these defects.
So we understand what the facts are here. That there was supposed to be flashing. The balconies fell. There was supposed to be flashing, and there's an allegation that there was fraud and it was concealed because there was the siding, and they were unable to see whether or not there was, or that the siding was deliberately put on to cover up, so that they could not see whether there was appropriate flashing. I do have one question, factually. Was the siding supposed to go, the siding was supposed to be there anyway? Is that right? The siding was going to be under that balcony anyway.
Right. In other words, the siding was going to go on anyway. And it is not our allegation that the sole purpose of the siding was to conceal the omissions and substitutions. It's that they chose to do things that would be quickly concealed by the siding. But getting back to the procedural point that I wanted to make, Your Honor, is that what Turner did, they brought an Article 75 proceeding and a 3211 motion. So what you have procedurally is a statement of claim that's the functional equivalent of a complaint, and then you have the petition that was brought in the lower court, which is a 3211 motion on the pleadings. And whether you view this case as a fraud case, a breach of contract case, or both, what the motion court did and where the motion court made a mistake was that the motion court found that the statute of limitations barred the claims, whether they were sounding in fraud or contract. And that finding was a factual finding that the court improperly made in a 3211 motion that was disputed based upon a hearsay reply affidavit submitted by Turner without any opportunity to frame up what would have been a conversion to a summary judgment motion if it was handled appropriately. So procedurally, before we even get into whether this is a fraud case, a contract case, or both, what the lower court did was they accepted what the affidavit, and it's a hearsay affidavit on reply that said, oh no, Mount Auburn's predecessor knew about the rotting and the leaking problem. And the judge and the lower court said, well, with that affidavit, they say you knew about it. So you don't get the benefit of the 2-year discovery rule on a fraud claim.
Stop 1 second. Are you referring to the affidavit of Carl Stewart?
Correct.
So Carl Stewart said that he received a call in May of 2012 from Dean DeVito at Oak Hill saying that the balcony began to pull away. And that is used as the time frame from which the statute of limitations began to run in the eyes of the defendant. Am I right?
You are, and Your Honor, if you look at
if I may, and he provided photographs as well, and they point out that this was 3 years before Mount Auburn purchased the project, and since Mount Auburn was assigned the rights and remedies, that's it. We're done, right?
Well, right. In other words, what Mr. Stewart says is that that our predecessor knew about it, and he put in testimonial and documentary evidence to support that. But
your argument is that you got ambushed because this was supplied in a reply?
That's one of multiple arguments. But yes, in other words, this court has held you cannot satisfy your burden to establish a prima facie case that the statute of limitations has run on reply, let alone in a hearsay affidavit on reply. But more importantly, Your Honor, if you look at the statement of claim, the allegations that were made were that the nature of the substitutions and omissions and them being concealed made them impossible to discover. We submitted in the context of this proceeding in the lower court, meaning not at the arbitration level, the affidavit of an expert, Andrew Rodriguez, who said that this could only have been a calculated intentional effort and an intentional concealment. So you've got these conflicting facts.
But there was provision, wasn't there, for an architect to be checking the site, to be monitoring the work?
No, but these are factual disputes. This is a 3211 motion, which is only did the statement of claim state a claim, and then and that's it. And as we all know, it's very common that statute of limitations defenses rest on disputed factual issues, and that at some point, whether it be at summary judgment or at trial, those factual disputes can be resolved and may very well dictate an outcome of the case.
So I have a different question. I have a different question. So with respect to the concealment issue and the fact that siding is put on very quickly after the basic work gets done, this flashing and this siding was underneath was on the garage, on the top of the garage doors upon which the balconies rested, right? And that flashing and waterproofing would therefore not be in the same visual as something on a roof, for example.
Right. In other words, so you have the raw wood, that's the structure, and then it's wrapped in what people call Tyvek or waterproofing. It's also flashed with a metal flashing, and then it's covered up by the siding. So you would never see it without destructive testing, similar to what this court talked about in the TIAA case.
Okay, thank you. Let's hear from your opposing counsel.
May it please the court. Good afternoon, Your Honor.
And you have a cross appeal, I believe, so please address that as well.
Thank you, Your Honor. I will very briefly. Most fundamentally, what occurred here is that the claimant, Mount Auburn, acquired this property, this project, about 10 years after Turner finished its construction of it from the predecessor owner-developer Oak Hill. And Mount Auburn purports to assert claims that it took purportedly by assignment from Oak Hill, not its own claims. And most fundamentally, this is a breach of contract case at best, which is what Justice Rackauer held. And breach of contract claims for alleged construction defects are subject to a 6-year statute of limitations from when the work was substantially completed. And here it was substantially completed in 2005.
Counsel, if I may,
Yes.
What is the role of the siding? How does the siding play into this? Because you're not talking about, let's call it a defect or an event, whatever you want to call it, that it would be discernible from the naked eye, given the fact that it's covered. Does the fact that it's covered make a difference?
None whatsoever, Your Honor. There are other states, for example, New Jersey across the river, that have a specific discovery rule for construction defect breach of contract claims. New York is not such a state. New York has no discovery rule. New York says breach of contract for construction defect has a 6-year statute of limitations, and it lapsed. What counsel wants to argue is that there should be a whole new rule under the law, that patent obvious defects are subject to a 6-year statute of limitations, but latent defects that are not obvious to the naked eye should be subject to a discovery rule. But that is not the law in this state. And so they try, because this is so clearly a time-barred claim, they try to do the expressly impermissible, dress up a breach of contract claim as a fraud or a tort simply by using language of tort. And as was asked here, pointedly and appropriately, it's not like the cladding, the vinyl siding was something inappropriate. It was called for. So if Turner had finished the project or purported to finish the project and said to the architect and the owner, we've done building your project, but we're not putting walls on the walls, that certainly wouldn't have been acceptable. There was no nefarious scheme to cover up anything by doing what the contract required. If Turner breached its contract by building this improperly, it's subject to a breach of contract claim, but it can't be here because that statute of limitations ran long before counsel's client ever acquired this project, about 10 years after the project was completed by Turner. With respect to the cross appeal, very briefly, hopefully you should never reach it because as the court below correctly held, the statute of limitations for every conceivable conception of this claim long passed and lapsed. The cross appeal only relates to if any of these claims are revived, should they go to arbitration or should they be litigated in court? And Mount Auburn contends that it accepted by assignment all the rights of its predecessor, and thus Turner should be bound to arbitrate with it as Turner was bound in the contract to arbitrate with its predecessor. However,
you would agree, counsel, that the affidavit of Mr. Stewart should not be considered given the fact that it was given on reply and that it contained new information which your adversary could not rebut in any way?
No, Your Honor, I would not. First, it's immaterial because of the primary reasons that Justice Rackauer decided the case, that this is breach of contract and an attempt to dress up breach of contract as fraud, and thus it is all time barred. And for those reasons, the affidavit need never be reached. But it was entirely appropriately submitted if the court was going to consider a fraud discovery rule, because it was submitted in reply to an argument that was raised for the first time in opposition. It was not our contention or Turner's contention that the discovery rule applied, and their admittedly detailed demand for arbitration made no reference to a discovery rule or that claim. We argued and made our prima facie case that the claims as they were alleged were time barred because there was breach of contract and fraud that was impermissibly duplicative of breach of contract. It was only in opposition when Mount Auburn raised the notion of there being a fraud discovery rule that could possibly apply that these issues became germane, and we properly submitted them in reply through that affidavit, and they certainly had an opportunity to address them. They could have asked for a surreply, but did not. This was addressed at length at oral argument before the court. And most fundamentally, they do not allege Mount Auburn, if they, as they contend, stand in the shoes of their predecessor, Oak Hill, needed to allege what Oak Hill would have been required to allege to assert a fraud claim. And that if Oak Hill was the claimant here, they would have had to allege we, Oak Hill, in fact, did not know of these defects. Mount Auburn doesn't get a free pass simply because it's a successor and trying to assert that claim by assignment. And critically here, they never alleged what Oak Hill knew or did not know, and there is a fundamental pleading failure for that reason. Thank you, Your Honors.
Counsel, Mr. Kaplan, we're back to you.
Your Honors, thank you. Let me quickly use my time. Number one, counsel, I believe, misstates the decision of the lower court, which on page 14 of the record, the decision is based almost entirely on the Stewart affidavit and the court's factual finding that Mount Auburn knew or should have known of these defects, number one. Number two, the statement of claim invoked very clearly and unequivocally the invocation of either the discovery rule or equitable tolling, and it was Turner's burden in their Article 75 petition to bring up and satisfy their burden that the statute of limitations was not told, or that in fact that the claims are barred. So it's not true that they learned about this for the first time on opposition, and that cannot possibly excuse the fact that they waited until reply to bring this up. I also want to point out, Your Honors, that we're not asking anyone to rewrite any laws. In arbitration, you don't have to articulate your counts. We pled claims that sound in both contract and tort in the statement of claim. It was the lower court that said, well, we think they're really breach of contract claims. Either way, under the circumstances alleged in the statement of claim, with the concealment and supported by the affidavit of our expert, Andrew Rodriguez, that these were intentional concealments, you have a dispute as to whether or not these things were intentionally concealed, which would invoke either the discovery rule on a fraud claim or the equitable tolling doctrine on a breach of contract claim. So we're not changing any law. We're following exactly what this court has found, what the CPLR says about the statute of limitations, and under these facts, to shut this client.
Judge Scarpullo, what are you claiming is the fraud? That they should have done it a certain way and they didn't, correct?
No.
What are you claiming is the fraud?
The fraud, Your Honor, is the concealment. In other words, I understand that there's.
1 second. That goes back to Judge Renwick's question. Part of the contract was to put up the siding, correct?
Correct.
And you're saying that they didn't put it up because they had to do it for the contract? They put it up for some other reason?
No. I'm not saying that, Your Honor.
I still don't get it. What's the fraud?
What I'm saying is by selecting using the wrong size lumber, no flashing, no waterproofing, and the wrong vinyl siding, they chose those things because they knew they would be quickly covered up by the siding.
And those are all things they had to do according to the contract, right? They had no separate duty or obligation to you. They had those contractual obligations to do that work. So other than those contractual obligations, where's the fraud?
It is the concealment, Your Honor.
But there's no concealment if they had to do that work anyway. Didn't whoever was there for Oak Hill have the responsibility to inspect? Weren't they looking? Wasn't there somebody around? I mean, they could have asked to see whatever it was, but beyond that, what was put up was supposed to put up. There was no extra reason for putting up that siding. It was the contract. They had to put it up. You're saying that they put it up for an extra reason. That's the facts don't show that.
No, but I'm not saying that, Your Honor. So if I can just have a moment to clarify. It was a convenient use of a requirement under the contract to put that up and select what they selected. They could have, in other words,
It sounds like you're saying the same thing. I don't understand what you just said. It was convenient. It wasn't convenient. It was pursuant to the contract.
No, but it was convenient to choose the things they chose to omit and conceal.
No, you keep using that word conceal.
Because they would be covered and not available without disruptive testing. Who should have been testing? Who saw what is up for is a dispute. The building inspector, and this is in the record, came in and said, hey, Turner got one by us. They got one by us by not waterproofing, by not flashing. They had the fire department out there, and the building inspector said, they got one by me. And that's what they did. They do it in a way that it's done quickly, and it's covered up by what, yes, is otherwise required under the contract.
It must not have been too quickly, or else somebody would have said, boy, that was awfully quickly. You keep saying these things like, oh, they did it quickly, they used the wrong thing, and they concealed it. I hear they used the wrong thing. They did not use what they were supposed to, but that they did it quickly, I would imagine somebody would have seen that. And the fact that they put the flashing, the siding up is not something additional or special.
But A, I think those are questions of fact, Your Honor. Remember, there's a 3211 motion. B, the intentional concealment has nothing to do with the discovery rule. It only has to do with equitable tolling. And in equitable tolling, it's an equitable doctrine. And if they chose to do things that would be quickly covered up and not discoverable until a number of years later when balconies rot out and fall, that is an equitable consideration that the court should make, has made, did so, well, recognize the ability to do so in the TIA case. And there's no exception here. But remember, this is a case that belongs to arbitration.
Thank you, counsel. Thank you both, by the way. Thank you both.
Thank you both. Thank you to the
Thank you, Your Honors.
Matter of Crawford versus Ally.
May it please the court. I am David Kornblau of Covington and Burling. We are pro bono counsel for petitioner appellant Ms. Shamika Crawford. This appeal presents a recurring due process violation with severe consequences for families ensnared in the criminal process. In this case, because Ms. Crawford was denied an evidentiary hearing, the criminal court erroneously entered temporary orders of protection that barred her from her home for 3 months.
So, counsel, I think forgive me if I'm wrong, but I think, do you agree that this is moot? The issue is moot, and that we are dealing with an exception to the mootness issue?
Yes, Your Honor. We are dealing with what I would say is a clear exception to the mootness doctrine, and the courts should reach the merits of this due process issue in this case because it is of great public importance. It's been recurring for many years and typically evades appellate review. Those are the standards for the exception.
So what I'd like to find out from you is, I mean, it seems like this comes up, but I don't know that it, in any case, this is an issue where you're saying that a hearing is required. We should have a hearing because this individual was denied due process. And my question is whether or not, and right now it's the discretion of the judge. The judge has the discretion to hold a hearing or not to hold a hearing. And my question is whether or not there is a need here in these cases to hold a hearing, or whether there was, in this particular instance, what the individual faced was a result of an improper, perhaps, exercise of discretion.
I would say not an improper exercise of discretion, Your Honor. Due process requires a hearing because of the significant impact on property and liberty interests.
But didn't this person, wasn't there an opportunity to be heard here when it was, I think, 2 days afterwards that they were coming back to be heard on the issues underlying the temporary order of protection that they were supposed to bring information about? Wasn't that the purpose of coming back 2 days later for an opportunity to be heard?
So there was no meaningful opportunity to be heard, Your Honor, and that's what due process requires.
Exactly, but the purpose of coming back was for due process, was for the purposes of being heard. Am I correct?
Well, the purpose of coming back after the arraignment was that the prosecution was supposed to investigate the situation that was going on in Ms. Crawford's home. They didn't do that. They repeated the same generalized allegations without evidence, and the court.
Exactly. But that the opportunity there, I'm just saying the opportunity there, it seems, was to be heard, was to provide the court with information. There were 15 or however many, 16 of these DIRs. At that point, I would think the prosecutor should have presented them. The court should have asked for them. That was the purpose at that point. And so that's why I ask if this is more the question about the discretion that was perhaps used.
I don't think so, Your Honor. The due process required an evidentiary hearing, and the problem with that court appearance, as well as the next one, is that the judge did not ask for evidence, did not put the burden of proof on the prosecution, and as a result, got it wrong. And there is just an enormous danger of erroneous decisions on these temporary orders of protection because of this lack of due process and the routine practice of the criminal courts not to hold hearings. It's led to a situation where the hearings are routinely denied, and there are many erroneous findings. And I would urge the court to take a look at the amicus briefs, not only the facts of this case, which are particularly egregious, and as Judge Stone recognized too late, a couple months later, but this is a problem rife throughout the system that causes.
So, counsel, I'm sorry. So your argument is that it would be a violation of due process once a defendant asserts that there should be a limited order of protection, not to hold a hearing to determine whether or not that order of protection should be limited or full?
Yes, Your Honor.
That would stem from what? Just a general constitutional issue of due process, or does that stem from the fact that you may be precluding the petitioner now from her home because of that full order of protection? Is it just a constitutional issue in terms of a lack of due process, a violation of due process?
Yes, Your Honor. It flows directly from the applicable procedural due process standard that the New York courts apply, which is the Supreme Court's Matthews v. Eldridge standard. And when you apply that test, because these temporary orders of protection impinge upon very significant property and liberty interests, such as Ms. Crawford experienced in this case, it triggers the need for a hearing, a prompt hearing, not a hearing at arraignment, but a prompt hearing.
Counsel, if I may, you're talking about a formal hearing with witnesses?
Your Honor, I would say that the exact nature of the hearing isn't really at issue in this case because there was no hearing. But at a minimum, what we ask this court to rule and give guidance to the criminal courts that consider these applications for temporary orders of protection, there should be a hearing when it's requested by the defendant. Both sides need advance notice of the hearing. Notice is an important central part of due process. The burden of proof needs to be on the prosecution to present evidence, to comply with the factors in CPL 530.12. There are very specific factors that the judge is required to consider. And then the defense has an opportunity to review, rebut, or correct that evidence. Exactly.
So you're talking about a whole layer of hearings that would now be required when a temporary order of protection is requested and a limited order of protection is asked to be substituted as an alternative.
Only when the defendant asks for that hearing, then I think, yes, Your Honor, the due process clause requires that there be an evidentiary hearing, a meaningful test of the prosecution's applications, not deference to the prosecution in the absence of evidence. That's what's needed.
What about if there's no
decisions right.
Oh, sorry. What if there's no property issue at issue? There's no property issue. I mean, you're assuming in every single case that it's going to be the person who owns the home who's kicked out of their home, but that's not true, right? So what if isn't it true that sometimes the judge could just say there's really no property or liberty interest here that needs a hearing? There's no due process requirement because no property or liberty interest is at stake?
Your Honor, I mean, I think that's right. There needs to be a constitutionally protected interest. It's going to depend on the type of order that the prosecution is requesting.
So you're not asking for a blanket hearing. I thought you were just saying a blanket every time that one comes up.
What we're asking for is if the prosecution is asking for a temporary order of protection that impinges significant liberty or property interests, then there needs to be an evidentiary hearing so that courts get to the right answer, so that these erroneous evictions.
So, counsel, the more we unravel this, the more issues I see. And I ask you, does this fall more properly in the realm of the legislature, which would be able to figure out all the details as opposed to us?
Well, it's the province of this court to enforce the constitutional rights of defendants.
No. I know that part. That's too easy.
Your Honor, I think that is the answer. I mean, what's going on, what went on in Ms. Crawford's case, and I think goes on in other cases as well as the immediate.
Well, that's what I wanted to get to, counsel. I know your time is almost up. I'm trying to get to that, the exception. Is there something in your papers that state that this is likely to reoccur? Is this an ongoing issue? Is this an issue that is likely to reoccur?
Yes, Your Honor. In fact, that is undisputed. Both the justice below and both respondents, everyone is in agreement that these temporary orders of protection are routinely requested by the prosecution in criminal cases involving family members, and almost invariably when defendants ask for hearings, they are denied. So this is a recurring issue. It typically evades review, and it's of great significance to the defendants who appear in the criminal courts and are subject to these orders and the potential for disastrous errors.
Thank you. Let's hear from your opposing counsels. There are two.
Good afternoon, and may it please the court. Blair Greenwald on behalf of respondent Judge Ali. Supreme Court properly dismissed this proceeding. I will rely on our briefs for the mootness argument unless this court has specific questions. But in any event, Crawford has not established a clear legal right to some requested relief and does not even attempt to do so before this court. She contends she does not have to meet the high legal standard for mandamus to compel because her case is now moot and can be addressed only by conversion to a declaratory judgment action. But mootness does not affect the underlying legal standard, and it certainly cannot make that standard more permissive. Regardless of whether
do you agree that the judges routinely deny hearings on these cases? That's what counsel said. Everyone agrees that judges never give these hearings. Do you agree with that?
No, Your Honor. Both looking at the local rules that we attach to our addendum to our brief, as well as even looking at the circumstances of this case.
Well, let's talk about that. Looking at the circumstances of this case, both Judges Ali and Judge Stone both said, you know, where there is something about the housing, they defer. So it seems like there are two judges who both said similar things with regard to cases when housing is involved. So it seems like that well, we don't look at housing, it's really we look at the victim. Well, sometimes those things are entangled, as it was here. It could have been a really bad outcome here.
While that's correct, that's not the framework that the court should be looking at for this reason. If there is a due process interest,
I'm sorry. I'm just speaking to the fact that you said no, this doesn't recur. And yet, in this very case, we have two judges, both who said the same thing about we have to look at the victim and we don't look at the housing issue. We don't look at those property issues. So that seems to me, I wouldn't have thought that, but the two judges independently said that.
It is undisputed here, even Crawford agrees, that the purpose of the hearing is to consider the merits of the temporary order of protection, which looks at the safety and protection issues, not the property issues. But how the property interests are relevant is that the property interests, if they're there, will trigger the need for a due process hearing. And hearings were held in this case. In other words,
how? In this case, a hearing, excuse me, just so, in this case, a hearing was held? Is that what you're saying?
Yes, Your Honor. So for instance,
is there a hearing where a judge says, we're not talking about that, where the person raises an issue and the judge says, we're not talking about that? Is that a hearing where there are 16 DIRs and it never comes, people never bring it out and the judge doesn't ask for it? Is that a hearing?
2 points on that. 2 points on that. First, the court assumed that she had a property interest. In other words, the court did not deny that she had a property interest. The court assumed she had one and therefore allowed her the opportunity to be heard on whether the temporary order of protection was necessary for good cause in order to protect the complainant. The DIRs are a separate issue, and the way I'd like to address them is twofold. One is that Crawford admits she had.
You're stating that there was a hearing, that the court granted her a hearing, but that she did not meet her burden in showing that it should not have been a full order of protection, but it should, excuse me, that it should have been should not have been a full order of protection. Is that what you're arguing? That there actually was a hearing, but that somehow she did not meet her burden?
So she admits that she had all of the DIRs in her personal records, but she did not present them to the court either at the November 8th hearing or the December 20th hearing. It only came up when she attached them to her Article 78 petition. And that is at
R20. Did the judge say, do you have any evidence? Do you have DIRs? Do you have any other evidence that shows that, you know, how this full order of protection is going to impact your life?
And I just want to ask an additional question. Whose burden is it to present the DIRs?
Right.
Right. So the question, she does say, Crawford does argue that the prosecution presented insufficient evidence to warrant the order of protection. While that is a legitimate argument for her to make, that is not procedural due process. In other words, procedural due process does not demand a particular outcome. It demands that
it demands an appropriate review of the appropriate evidence.
Any evidence or call any witness. I'm sorry.
I'm sorry. You were freezing. You couldn't hear me. I couldn't hear. I said, doesn't it though demand an appropriate review of the appropriate evidence? Proper review of the appropriate evidence. Doesn't procedural due process require that?
I'm sorry, Your Honor. It froze.
Am I freezing? I cannot tell.
Sorry, the screen is
freezing.
Are you there now?
Yes, please, if you could repeat your question.
I was just saying, doesn't a due process demand a proper review of appropriate evidence, which doesn't seem to have happened here, where there was an opportunity, but where there was, the court assembled everyone back together, but I don't believe provided an opportunity for people to be heard, where they were just cut off. They weren't allowed to raise the issues and actually explore them.
She was permitted to present any evidence or even call any witnesses that she liked. She did not ask to call any witnesses
even
or
with
submit any
regard to
evidence.
the lease. She was able to give that position that she lived there, but she wasn't able to present the lease that was, he doesn't live there. His name is not on the lease. He doesn't live there. That was step one. Then you were getting to the issue with regard to the DIRs and whose burden it was.
Right. The issue with the lease documents is that it's irrelevant here because the court assumed that she had a property interest and therefore should be entitled to argue and present evidence on the justification and good cause for the order of protection. In other words, the fact that she had a property interest means that her case was adjourned to the DV part and she could have a hearing in order to present any evidence she wanted showing that the full order of protection was not warranted because she did not present a threat of intimidation or injury to the complainant. The scope of the hearing is limited to that safety merits issue. It is the property interest that triggers the need for the hearing. So the court assumed she had a property interest, granted her the hearing. She had actually in her possession all of the DIRs in her personal records, as counsel admits in the record at page 21 at footnote 1. She did not present those to the court until—
I'm asking you again, whose burden is it to present those? Whose burden is it to present those DIRs?
While the framework may place the burden on the prosecution,
it may. I'm asking you, when you say the framework may, is it on the prosecution or isn't it?
Well, so depending, if it's an application to modify the order of protection, then the burden is on her. If it's the prosecution seeking to implement an order of protection or to renew it, then the burden is on the prosection.
Well, it was seeking to implement it. The
November 8th.
Initially, the prosecutor said we want a temporary order of protection, a TOP, and her counsel said, please make it limited. I'd like it to be limited. And the prosecutor said no. And the judge said, well, I'm not going to do it if the prosecutor doesn't agree, without any evidence at all of these DIRs.
Right. So the prosecution relied primarily on the discussion of, on the verified complaint by the alleged victim, as well as the discussion of the crimes. The DIRs, the prosecution brought up November 8th.
Okay. All right. Sorry, you finish it.
Right. So the only thing I'd like to emphasize is that the alleged errors in the sufficiency of the evidence to support the order of protection or the burden of proof all go to potential legal errors in the determination. But procedural due process guarantees a specific type of procedure. And here, Crawford does not ask for any specific type of procedure. Due process only guarantees the right to be heard, and she had the opportunity to submit evidence or new argument at any time and was invited, in fact, to ask for the opportunity to do that at any time.
Thank you. Mr. Anderson, I believe.
Yes, Your Honor. Thank you. Good afternoon, and may it please the court. Paul Anderson on behalf of respondent Darcel D. Clark, District Attorney of Bronx County. I guess to go into what
I'm going to start, I guess, where I left off. Whose burden is it to present these DIRs?
I guess it depends on what the DIRs are being offered for. So in our case, we can meet our burden based on a first-party complaint, which is what we did here. And then when there's DIR history, we didn't get to finish to say why that history was relevant and that this could have shown motive, or this was a fact. Our theory of the case, as we did in the later proceeding, was that these DIRs, the history of attacks by the complaining witness on defendant, was the motive for this ultimate attack.
Okay, I'm sorry. You said something just now where you said you didn't get to do something. I'm not clear on what you're saying. Well, this was a case where we have the complaint, and then we have in front of the judge, you asked for the temporary order of protection. And the other party, Ms. Crawford's attorney, says, make it limited. This is her house. She needs to go in there. And that's it. And then it was, we're not bothered with the house, and we're not bothered with property. And I don't believe that the prosecutor at that point ever said anything about the DIRs.
I guess you're talking about at arraignment, Your Honor. I thought we were talking about the 5 days after arraignment. So yes, at arraignment.
I thought it was 2 days after arraignment. I'm talking about the 2 days after arraignment. Whatever it is, I'm talking about the period immediately following arraignment where they came before the judge, presumably to be heard.
Yes. So we said, based on the injuries, we still want this order to be issued as full order, based on these first-party complaint, the nature of the injuries. And in response to that, defense counsel argued that there are grave property and family interests here. Did not discuss anything about the safety, which is what the overriding concern is for 530 here.
And so that you, in possession of these 15 or 16 DIRs that show perhaps something other than the person who was Mr. Meyer, or whatever his name, show something other than him being mayor, show something other than him being the victim, did
Yes, Your
not
Honor.
come before the judge. Nothing was said about that?
No, Your Honor. And I'm looking at page 89 right now. So at this time, there's also an extensive DIR history, Your Honor. I believe about 17 DIRs. And then it goes the court. So I didn't hear this case on the 3rd. Let's go backwards. And then what goes to defense counsel? Let me hear your application for a limited order. So this is after we've already
I'm just confused because you're the prosecutor. You have the DIRs. It says she's the victim. Whose burden is it at this point? Do you just not present to the court something that is clearly impactful here on both parties? You just hold it in your pocket? Why doesn't that come out? Who has that information about the DIRs? Did you know it? Did you have it?
Yes,
the judge didn't ask a specific question about the DIRs. The judge said, let's go backwards, so it never came out?
Yes, Your Honor. Defense counsel had the opportunity. Defendant knew about these DIRs, as my colleague just noted.
Back up 1 second. So the petitioner is claiming that this is an ongoing issue. It's recurring in that there is no hearing, that these hearings are not being held. So my experience was that they were being held and that the defendant could, or the whomever could ask for a TOP hearing. So is it something that is being done? Are these hearings being conducted? Yes or no?
Your Honor, how it's being done, in my knowledge, is no, Your Honor. It's there's an opportunity. We can advance the calendar.
I'm sorry, they're not being held. Is that what you're saying?
I guess my question is, what type of hearing is Your Honor discussing?
A TOP hearing, a hearing to determine whether it should be a limited order of protection versus a full order of protection. Are these types of hearings being held? Yes or no?
They're not testimonial, yes, Your Honor, but they're not full testimonial unless the court asks whether they're wants it to be a testimonial full hearing.
So why would so that's the point. Why is it up to the court? Why would it not be up to the parties? Why would it not be up to the individual who is claiming that they are being aggrieved by the full order of protection as opposed to a limited order of protection?
And here there was that request specifically for a hearing.
Right.
Yes, Your Honor. Yes, Your Honor. But it would be in this discretion the same way it would be in the discretion of the court to not hold a full securing order hearing or a full bail hearing. So
if it's a due process issue, why is it discretionary? Why does discretion come into play if we're talking about a constitutional due process issue?
Because the Constitution does not require a full testimonial hearing, Your Honor, just an opportunity to be heard. And yes, there could be times where that could be appropriate here, but to say that automatically off the cuff a full testimonial hearing is required any time for the asking, that's just incorrect. It's just
why
it's not part of the due process clause. Does not require a full testimonial hearing for limited
orders. Even when you're talking about the loss of a property right?
Yes, Your Honor, the same way that it doesn't require it for loss of the person's liberty for bail, for pretrial. It's at the information available. Yes, you can seek it. So yes, it could be a case-by-case basis, but in no way is the hearing available just for the asking. And as
Judge
Gonzalez, I think, pointed out, this seems like we're legislating from the bench here, trying to figure out.
Let me jump in here since my name was invoked. So here you have a NYCHA apartment where the defendant is the person on the lease and the victim, I'm going to call him the victim, is not. He's not on the lease at all, which therefore means he's an unauthorized occupant. And his staying in the apartment is a violation of the lease. So you have a conundrum, to say the least. And at the same time, you have domestic incident reports in hand, which are not disclosed to the court as to who the victim on those reports is. And the victim in this case was the defendant. Her name is clearly on the reports. I mean, it says name of victim and there she is. So I guess I'm bringing up issues that my colleagues have alluded to. Isn't the burden of proof on the people to show if they have documents in hand that show that this person is the victim in 15 named in 15 domestic incident reports? Don't the people have an obligation to disclose that to the court as well as to the defendant? What are we doing here?
Well, I guess that nearly goes really outside the scope of should a full hearing have been ordered. But in terms of that, I guess, yes, it could have been disclosed or should have been disclosed in the 5 days later. I don't know what discussion.
Reference to it. The people made reference to it as a basis for issuing a full TOP.
Yes, Your Honor, but I think once again that could cut both ways.
But the TOP therefore is based on faulty information. That's problematic.
I would disagree with that, Your Honor, because if you could have 15 DIRs against a person, and then that person can later kill the other person, it's not dispositive. And as to the crime at issue here, which we argued later, that that could show the motive for why she tried to violently throw him out of their shared apartment. And once again, this was a shared apartment. It wasn't an overnight guest. As Judge Alley noted in the CJA report, she reported she lived with him. And in all those same DIRs, it showed that they lived together, that she reported that they lived together. And so the conundrum here was really, how do I go back? There was an attempt to turn criminal court into housing court and to our family court, which is what exactly she argued, or counsel argued on page 89. Your Honor, I want you to make this limited because of the housing and family court concern, or housing and family concerns, not for any public safety issue.
Oh, you're
walking. I want to go back to a different issue with regard to
can he just finish exception. Can he just finish that 1 second, if you don't mind? I
thought he finished it. Go ahead. You have another question.
In the family court.
Well, in terms of on page 89 to 90, the first argument that counsel makes, the primary argument for saying, Your Honor, I want this to be a limited order, is because of the grave family and property concerns that have resulted as a result of that order. And that's the forefront. And then later we see in front of Justice Stone, I don't have the page, but counsel Mr. Northrup said, we don't want to go through eviction courts. It's not the most expedient way to handle these. So really, yes, and to go back to Judge Renwick's concern about do courts look at housing? Yes, we look at housing. We don't really look at property rights. Every arraignment part I've been where I've asked for an order, especially when it's domestic, who lives where? That's always a concern. But it's once again, who actually has the superior property right or who can evict someone else? That's not appropriate for criminal court here. And so, especially when we have cases like this, where this was, at least our theory of the case was, this was a constructive eviction. Get out. Or else, or I will F you up, get out. And so taking this all together, I guess, to try to get back to the primary issue.
I guess that's mainly because, not that I want to go off track, but mainly because all those DIRs showed that she was the one who was the victim. Anyway, I have a question with regard to mootness. And I want to know whether you believe that there is an exception to the mootness doctrine here.
Your Honor, I would, no.
Why not?
We conceded the first fact that these type of concerns will arise again.
Come up often.
Yes, but in terms of typically evade review, no, we provided, yes, the Civil Supreme only quoted to one case. Both me and my colleagues cited to many cases where these have been challenged, where this can come up, whether there could be a writ of prohibition, whether it could be on a direct appeal of a criminal contempt charge. There's always an opportunity for that. And whether it's substantial and novel, there have been challenges from the 1980s to whether 530.11 creates a due process violation. And so anything else, it seems like we're just going to be telling the legislature how to legislate or how to make these type of hearings, which I get why defendants would, or why people would want a hearing for these types of things. But I don't think in this posture, in an Article 78 that everyone concedes is moot, it's appropriate to try to craft the type of hearing here. And so, if Your Honors have no questions, I ask that you affirm.
Thank you. We're back to you, Mr. Kornblum.
Thank you, Your Honor. So on the DIRs, Ms. Crawford did not have them. which is why the burden does need to be on the prosecution. This is not in the record, but in fact, she went to 2 hearings. She heard the DAs talking about them. She went to the precinct herself, got copies of them, and that's how we were able to include them in the Article 78 and put them before the court. That's the only way they got
on the
before
burden
the
of
court.
proof, if you do have this type of a hearing, why would the burden not be on the petitioner who is requesting that it be a temporary, limited, as opposed to a full order of protection? If the people come forward with proof saying it should be a full order of protection, the complainant is fearful of the defendant, fearful of being assaulted, etc., and therefore that the defendant should be barred from the home, why would it then not be on the petitioner defendant's burden to show that it should be limited and not full, and then perhaps coming forth with evidence such as the DIRs, etc.?
Well, Your Honor, I would say it's the prosecution's burden. That the prosecution is trying to burden the defendant's liberty and property interests. If they come forward with evidence that they believe supports a full order of protection, then yes, the defendant should have the right in a due process hearing to put forth evidence showing that a limited order would be sufficient, or maybe no order at all is more appropriate.
But is there not a presumption that a full order of protection is the type of order of protection that should be in place in cases?
Your Honor, definitely not. A presumption would not be consistent with due process. It needs to be based on evidence. The burden needs to be on the prosecution to show that there is a basis for impinging on these constitutionally protected.
So then, taking this one step further, as was issue by Justice Gonzalez, would that not mean that then in every case the prosecution would have to show that a full order of protection was the proper type of order of protection? Well, isn't that a burden, the burden that we'd be placing on the prosecution each time they ask for an order of protection?
Well, yes, Your Honor, they should have evidence and they should have an adequate basis every time they request a full order of protection. And it's only when the defendant asks for a hearing that the due process hearing kicks in, and the court needs to make sure that it carefully considers all the factors in the statute, CPL 530-12, and gets these issues right. And to go back to your earlier point, Justice,
if I may,
please.
Your adversary, the people, say that the criminal court, you're saying that the criminal court has jurisdiction to issue temporary orders of protection, limited orders of protection. It therefore has jurisdiction to hold hearings. But the people seem to be saying that you have a remedy in Article 78 if you don't like what goes on. I don't know that it would be going to housing court or family court. It appears that the argument is you have an adequate remedy there in lieu of having a mandated hearing. What say you in this regard?
Not adequate under due process, Your Honor, because due process requires not only a meaningful opportunity to be heard, but at a meaningful time. And imposing the order that impinges on these protected interests, and then saying, well, you can always fix it by initiating a new proceeding in another court and following the calendar of that court, that does not adequately protect the interest. And it would essentially mean that these temporary orders of protection would stay in place. Sorry?
Arguably, you'd be able to ask for a TRO and have a hearing pretty fast. So you don't think that would be enough?
Not under due process, Your Honor, because what's important is that the court gets these decisions right in the first instance, not that the defendant has some ability to go seek some other judicial review to fix the mistake that was made. What's important is that there be a due process hearing so that the judge.
And when you refer to a due process hearing, are you referring to something necessarily testimonial? A hearing that's necessarily testimonial?
I would say that both sides should have the ability to present testimonial evidence if they think that is relevant and helpful to the court. I don't think it's necessary. In this case, Judge Stone didn't find it necessary, but Judge Stone, and I wanted to get back to Justice Weber's comment earlier about her recollection of her practice in in top matters, on the record in this case, Judge Stone said in January 2020, it is this court's practice not to conduct a hearing. So there's really no dispute in any quarter of this litigation that these hearings are not being held, and
Counsel, this is Judge Scarpula. Could that be meaning we don't take testimony? I mean, he's hearing you. You're there, they're there, you're arguing. That's a hearing for due process purposes. But I think couldn't that statement be we're not going to swear in witnesses in this type of hearing? Isn't that a fair way to assume that that's what that meant?
I don't think so, Your Honor, because Judge Ali went way beyond.
You're there, correct? Then I mean, your client's there, the other side's there. You're both making arguments to the judge, correct?
Yes, they can make arguments.
That's a hearing, a due process.
I would disagree, Your Honor. Under due process,
you have to have testimony.
Not necessarily, but it needs to be a meaningful hearing. The burden of proof needs to be on the prosecution to support the application with evidence. Both sides need advance notice of the hearing, and the defendant has to have an opportunity to review, rebut, or correct that evidence.
So you're saying you want more than oral argument.
Oral argument is not enough. The way that a court can avoid making this kind of error is by looking at real evidence and sorting through it, including these property issues which are inextricably intertwined with many temporary orders of protection. What happens in this case was the judge says, I'm not going to get into property issues, but then he decides them in the prosecution's favor by concluding with no hearing that the complainant had a right to live in this place and mentioned the specific address. He made a finding on a property interest issue while saying we don't do property interest. It's not a sensible system.
Thank you very much. Thank you to all the attorneys. GLCA Securities versus AGC Networks.
Good afternoon, Your Honors. I'm Kevin Schlosser from Meyer Swazi. We represent the appellant. May it please the court. So as you can see from our briefs, we find a great amount of significance in the phrase of the contract at issue that explicitly states that the services to be performed by the plaintiff are, quote, in connection with arranging a financing of capital securities, which it defines as financing for the company's prospective acquisition of all or part of Black Box. That's a key significant phrase in this contract because it sets the tone for the very purpose of the contract. Plaintiff was hired to arrange that financing. And what happened here is,
Counsel, this is Judge Scarpula. Where does it say that in the contract? There's a list of things that the plaintiff's supposed to do, right? The scope of services. Where in the scope of services does it say plaintiff has to arrange the financing in order to get paid?
Okay, so there's a few responses to that. One,
I just want you to read the contract. You say this is what the contract says. Well, I'd like you to just read it. Where is that?
Okay, it's on the very first paragraph of the contract. It's page 64 of the record, and I can read the whole paragraph if you wish.
Just tell me where. I didn't see that. I don't see those words, so I'm wondering where are those words?
Oh, these are critical words. They're in the very first paragraph of the contract, and it says after it identifies the services that are to be performed, it specifically says in connection with arranging a financing.
Got it, because that's the whole purpose. You need money to buy the property, right? So you want this, but I'm saying where does it say in the contract that this party has to do that?
Okay, so the services
in connection with doesn't mean that I've got to raise it. Where in the scope of services, which is what that party is doing for you, does it say you must raise $10 million, you must raise $100 million, you must raise 3 cents?
Okay, it says to act as agent and financial advisor to the company and to provide financial advisory services and investment banking services in connection with arranging a financing. So
I'm
it's,
talking
I've
about
never
in-
seen so many prepositional phrases in my life. If it was going to say for financing, why wouldn't it just right away get there and say for financing? Your services are for financing or to arrange financing. Instead, you have in connection with arranging a financing of capital. How does that really?
Hey, I get it. I didn't write this. It's not
Well,
the
I'm not blaming you for writing it, but your
No.
argument is that it's ambiguous or something when I don't see, like my colleague, I don't know where here it says they were supposed to be arranging, getting the financing. You get the financing.
There's two responses. It would be redundant if in the list of the services, it said in each and every occasion in connection with arranging the financing. For
But it
example,
would have been okay if it said it in that one
here-
opening paragraph.
It did.
I think that's, my colleague has a question.
Yeah,
because they're
you don't
proposed.
have the word procure financing. You don't have the word obtain financing. You have the word, I'm going to help you out in exchange in connection with all of these financing issues. But you don't, it doesn't say, I'm going to get it for you. You have to get it for me, rather.
Okay, so it does not say in attempting to arrange the financing. It says in arranging the financing. And it
says
also
in
does not
connection
say.
with. It says in connection with
In connection with arranging a financing. It's going to perform all these services and it's modified with the phrase in connection with arranging the financing. That modifies all the services. It has to be in connection with arranging the financing, not attempting to arrange the financing, not working if somebody
Arranging the financing, I don't, yeah, okay.
It's to arrange for them to receive the financing to procure this company. But Judge Gonzalez, it also doesn't say if you don't obtain the financing, you're still entitled to your fee. The fee is tied back in. It doesn't say it either way. It doesn't say you're not entitled to the fee if you don't get the financing, and it doesn't say you're entitled to the fee regardless of whether you obtain the financing. This is not an exclusive arrangement whereby the plaintiff gets a fee no matter if it finds the financing or somebody else does.
This is very, I mean, I've been looking at this appeal, and this is most unfortunate phrasing, if I may.
That's the very point.
It really, really is, because it does look with just a plain reading of the contract language and not getting fancy or anything or going down alleyways. It does seem as though as long as GLC agreed to provide financial advisory services and investment banking services at the moment where somebody procured the financing, it was in for payday, a great payday.
Okay, but
and which is the parties are free to accord such compensation.
That's a fair reading of it, Your Honor. The only problem here is we're on a motion for summary judgment, and if there are two reasonable interpretations of this contract, then the court cannot grant summary judgment.
But I'm talking about a plain reading, Counselor. I'm not talking about two readings. I'm just saying, doesn't it say what it says?
Well, so the fee that is described in section 2 on page 65 of the record, okay, it doesn't call it a services fee. It doesn't call it an advisory fee. It calls it a financing fee. And the financing is defined by definition in connection with the acquisition of Black Box. It ties it all back in. The financing fee.
There are plenty of cases where someone hires a mortgage and an investment bank to help them put their stuff together, to get packages together, and they don't get the financing. The services that they do enable the company to present a package to a prospective financer. So my question to you is, when I look at the scope of services, which is what the party agreed to do, that's what I want you to focus on. What the scope of the engagement does not say get financing. It says do this, the A through F. None of it says get financing. And I mean, it could have, but it didn't, right?
Absolutely correct. And you.
Thank you. And I want you to respond to that on your rebuttal. Counsel, Mr. Besden. Yeah, and you have a cross appeal, so address that as well.
I will. May it please the court, good afternoon. My name is Noam Besden, counsel for respondent appellant GLCA Securities. I think as the court just identified, GLC is a financial advisor that provides advisory finance services to its clients, and it was hired to provide these advisory services to AGC.
But what about the fact that counsel says that, you know, there was, I think the two kinds of financing here was Pathlight and Pathlight and Encina, was it?
Mm-hmm.
Pathlight and Encina, and that Pathlight brought Encina to them. So
Right.
were they really doing, even arranging? I mean, were they even putting these packages together if other people were bringing it to them?
So
I guess I'm asking then, what aspect of the provision in the language of the agreement did they actually do?
Well, thank you, Your Honor. I think if we look at the agreement and look at, I think Judge Scarpula just referenced A through F, which is on page 64 of the record.
Yes.
Right there, there's no dispute that those services were performed. On summary judgment, GLC put in that those services were performed. There's ample evidence in the record of it, and that's never been disputed by AGC. From the due diligence described in section 1A to the assisting the company in preparing all the materials for the information memorandums, for advising and insisting in terms of obtaining and analyzing the proposals, all of that was done. And there's no dispute that was done. In fact, and I'm glad Your Honor brought this up, in fact, according to AGC's read, the moment an introduction is made by some other party, according to AGC, GLC is cut out of this loop, right? Because GLC didn't make the introduction. But here, there's no question Encina and Pathlight are involved in, let's be generous and say September 2018. And after they're involved in this deal and they actually submit a commitment letter together, GLC and GLC is still advising AGC for weeks, if not months after. AGC is still seeking GLC's input, advice. The big meeting that occurred where AGC presented this proposal to the acquisition entity Black Box's debt holders, GLC was there. GLC prepared the materials and GLC participated. Now, if GLC's right to be paid these fees evaporated when, quote unquote, someone else introduced these entities, which is what AGC contends, then the fact that GLC was relied on and continued to provide services for months after those quote unquote introductions would make absolutely no sense. We've raised this in our briefing and there's been no answer about why AGC would rely on or seek services from GLC if these introductions, as they call them, have already been made. As for the payment structure under Section 2A, which is on page 65 of the record, again, our position is pretty clear and pretty, one reasonable reading of it. It says that there's a cash fee due to GLC of 1.75%. There is a carve out from that of 0.5%, only with respect to entities that are listed on Schedule A of the agreement, which is on record page 75. We're not disputing that Pathlight is on that schedule. So there is a party that brought in funds that would be at the 0.5% rate, and there's a party at the 1.75% rate. There's nothing in that schedule or in Section 2A of the agreement, however, that suggests that those rates are based on, again, who introduced or procured or quote unquote arranged these financings. And so what AGC is contending is there's no dispute, and it's actually in their answer, there's no dispute that Encina provided, that's the language they use in the language of the agreement. There's no dispute Encina provided $39.887 million. And there's no dispute that Pathlight provided, I think it's $42.5 million. They're saying, well, we haven't proven, or they have the right to prove before, I guess, lower court, that the only reason the second party provided the money is because the first party brought them in. It's the same argument as to why we shouldn't get a fee at all, and it's the argument rejected by the lower court. And that's the subject of our cross appeal, which is we think the lower court got everything right, except that it's requiring us to attend a further proceeding to determine these damages amounts when the rates I just described, 1.75% and 0.5%, are not in dispute. And the amounts themselves that the investors provided are not only not in dispute, they were admitted in AGC's answer. So if you have the dollar amounts and the rate, it's unclear why the lower court couldn't have made that damages determination. And the only argument that AGC has presented as to why we would need a hearing is because of this introduction argument that the lower court rejected. Thank you.
Thank you. Mr. Schlosser?
Sorry, thank you.
Mr. Schlosser, I'm looking at language in paragraph 2A of the agreement that says provided, the one about the financing fee. It says provided, however, that for any financing proceeds provided by any of the parties listed on Schedule A as amended from time to time, and that would be by AGC and GLC. It doesn't say, it says, it looks like it's talking about people other than GLC, doesn't it? Or am I reading that wrong in your eyes?
Yes, I do, because there's two different aspects here. GLC was hired to obtain the lender, to bring in the lender to provide the financing. So GLC wouldn't be providing the financing, they'd be arranging for that financing. The company that provided the financing, that brought in the financing, would be the lender. And so they have lenders listed in Schedule A. And what they're saying here is, if the money comes from a source that's on Schedule A, the lender on Schedule A who brings in the money, then that's going to tie into the fees there. It doesn't have to do with arranging that lender. And all I can say is that I believe that the analysis that's being accepted renders in connection with arranging this financing for Black Box to be meaningless. And the judge specifically said in her decision that GLC was hired to provide services and not to arrange financing. That's on page 16. That just renders this contract language meaningless because it specifically says in connection with arranging the financing. And, you know, that's an argument. And this is summary judgment. And yes, the contract is not written clearly, and it would be great if it said one way or the other. You either get a fee if you get the financing, or you don't get a fee, but it doesn't say that. And we're not asking for the court to determine that we win this contract case. We're just asking for a fair determination that doesn't summarily reject the language of the contract.
Thank you.
Just as far as the legal fees, you know, we have that entire argument under Hooper that there's not a clear, unmistakably clear agreement to pay their legal fees.
Thank you. Mr. Breslin, you have 2 minutes.
All right, I'll try and quickly respond. First of all, just in terms of the factual dispute that Mr. Schlosser just referenced, our position is there is none. In other words, the agreement says what it says, and there is no need for further adjudication to determine anything about the meaning of the words in this agreement. That's what the lower court found, and that's what we hope this court will find. I also want to just quickly refer the court.
Well, he says it renders it meaningless. The words financing meaningless.
I mean, but again, the services are defined. The scope of the services are then listed in the 6 subpart section. The fee is then again tied in the fee part, the compensation section, again back to those services. And if you look at the top of page record 65, the agreement specifically says, I'm quoting, the advisory services and compensation arrangements set forth herein do not encompass any other financial advisory services not set forth in this section 1. I don't know how much clearer the agreement could be on what it was GLC was retained to do. I'd like to very briefly respond to the point on the indemnification. Just to clarify, there's no question, obviously, that Hooper controls. What Hooper says is you look to the intent of the parties and you, I guess, reject language that is susceptible to third-party claims. Our argument, what the lower court recognized, was the language in this indemnification section here specifically says that the indemnity is in connection with advice or services rendered or to be rendered by GLC pursuant to the agreement. That section limits the indemnity to what GLC has performed under an agreement. The only other party to this agreement is AGC. It's a bilateral relationship. AGC has not been able to explain what could be susceptible to a third-party claim in terms of the services GLC performs for AGC. And I just want to close by pointing out that's nothing controversial. This court has basically found that exact carve-out in Crossroads ABL LLC versus Canaris Capital Management. There, even though it was a broad reference to any and all claims, this court found that the indemnification provision is read to include any claims intra-party or otherwise that involve Crossroads by reason of its services to Quad C, meaning in a situation where the indemnity is for the services provided by two parties to an agreement, we don't have the Hooper concern of third-party claims being the intent of the parties.
Thank you. Thank you both.
Thank you.
VXI Lux Holdco Company versus SIC Holdings.
May it please the court, David Heck for plaintiff appellant. My colleague Jonathan Weiss has been admitted pro hoc vice. So I respectfully request Justice Renwick that he be allowed to argue here today.
I will grant that request.
Thank you, Your Honor. Thank you very much. And also thank you for allowing me to appear virtually today. May it please the court, Jonathan Weiss from Proskauer Rose on behalf of the appellant, VXI Lux Holdco. In its decision below, Your Honors, the Supreme Court did not question that VXI had alleged actionable misrepresentations and material omissions. Instead, the Supreme Court granted the respondents' motion to dismiss VXI's fraud claims on three narrow grounds, each of which I'd like to discuss briefly in turn. First, the Supreme Court held, without citing to any case law, that VXI failed to sufficiently allege reasonable reliance, that it didn't allege that it did enough in the due diligence process related to the acquisition. And we respectfully submit, Your Honors, that the Court of Appeals decision in DDJ Management LLC v. Roan Group, which we cite extensively in our papers, is controlling and absolutely on point and disposes of this issue. In the DDJ Management case, the Court of Appeals first observed, in the words of the Court of Appeals, that the question of what constitutes reasonable reliance is always nettlesome because it is so fact intensive. And then for that reason, ordinarily, the question of reasonable reliance is not suitable for disposition on a motion to dismiss. In that case, the Court of Appeals held that the plaintiff, who had engaged in a $40 million debt finance transaction, so these were sophisticated parties with a lot of money at stake, that plaintiff alleged fraudulent inducement. The defendant said, you know what? You didn't adequately plead reasonable reliance because you didn't review the financial statements. You didn't do any inquiry whatsoever. And the Court of Appeals held that because the plaintiff had asked for and secured written warranties from the defendant stating that the financial statements were complete, truthful, and accurate, that in and of itself was sufficient to establish at the pleading stage that it had properly alleged reasonable reliance. And the reason the Court of Appeals held that, Your Honors, is because the touchstone of reasonable reliance in adequate pleading is that you adequately plead that you took reasonable steps to protect yourself from the fraud. And the Court of Appeals held that simply seeking and securing a written warranty with respect to the very facts that are later the basis for the allegations of fraud, that in and of itself not only constituted a reasonable step to protect yourself from fraud. But again, in the words of the Court of Appeals, what reflected significant effort to protect yourself from fraud. That was enough in the DDJ management case. We have multiple warranties and representations related to the specific issues at play in this case, related to whether or not they properly paid their taxes, whether or not their social insurance taxes and housing fund taxes were properly paid, whether or not their financial statements were complete, true, and accurate. There are even specific representations and warranties that say that the defendant Symbio and all of its employees, representatives, agents, and officers and directors, they did not engage in bribery of any government officials. It specifically states that. All of these are representations and warranties that BXI bargained for and received. That is enough under Court of Appeals precedent to establish that it pled adequately reasonable reliance. But lest there be any ambiguity about this, over and above the DDJ management fact pattern, here VXI not only secured all of these reps and warranties, but also had due diligence meetings in person across 3 continents, in Asia, in Europe, in the United States, had a data room where they put all of these financial statements and disclosures and information, reviewed that, engaged a Big 4 auditing firm, PricewaterhouseCoopers, to audit the financial statements, engaged in follow-up inquiries, specifically asking pointed questions that were raised, did all of these things in addition to securing the written warranties. I respectfully submit this is overdetermined here that there was adequate reasonable reliance pled in this case. The second ground on which the Supreme Court held that these claims should be, the fraud claims should be dismissed, again, without citing law, was that the damages alleged were speculative. And particularly that because there were allegations of the underpayment of the social insurance and housing fund taxes, that whether or not there'd be tax penalties in the future or liabilities in the future was an open question and speculative. But the damages that were alleged at length and with particularity in the complaint are precisely the kinds of damages that this court has recognized you can seek for a fraudulent inducement claim. That's the Comiva Group v. Garda decision from 2017 in this very court. And in fact, it was a unanimous affirmance of Justice Scarpulla's decision in the court below. That case set out quite clearly that for a fraudulent inducement claim, the measurement of damages is out-of-pocket damages, the out-of-pocket rule. And what that says is the measure of damages is the price you paid for the asset versus what it was actually worth when you acquired it. That's precisely what we allege in the Second Amendment complaint. BXI paid $112 million for the defendant Symbio, and the value of defendant Symbio was worth a lot less than that. Why? Again, because the valuation of the company was a straight multiple of its earnings, of its EBITDA. And we allege at length in the complaint that the EBITDA was artificially inflated. Its earnings were inflated because they understated their tax liability.
So let me just ask you, then how do you get around Judge Branston's decision that the EBITDA was not, that your reliance on the EBITDA, because you pled that before, right, in a previous iteration, wasn't sufficient to allege fraud? How is it different this time? EBITDA is an estimation. You're looking at future EBITDA, right?
No, that's
the difference? Are you saying that in the previous iteration of the case, she was looking at your allegation that you were looking at forward, and you were saying now you've pled something different?
Yeah, so the important point here with respect to EBITDA is that it was based upon 2014 EBITDA. 2014 EBITDA, when they started negotiating this transaction, they were deep into 2014. It was in mid-2014. So they already had half of the year's EBITDA. We allege specifically that those EBITDA numbers were misstated. And those half-year results that were in the past at that point in time were then used as the basis for a projection. So while projections are, not actionable in and of themselves, if they are based upon misstatements, known misstatements, then they are actionable.
But didn't you plead that in front of Judge Branston and
Well,
didn't he dismiss that claim? That's what I'm asking you. Why is it a good claim now when it wasn't before her?
What Justice Branston focused on in dismissing the case, the first go around, and particularly the fraud claim, and as you're well aware, that you reversed the dismissal of the contract claim on appeal unanimously in a published decision. Justice Renwick, you presided over that decision. What's different now?
Actually, Justice Manzanet wrote it.
She wrote it, and you were the presiding justice at the oral argument. And what Justice Branston was focused on was that there were no allegations or insufficient allegations to connect the allegations of non-disclosure and material misrepresentations to the individually named defendants, the CFO and the CEO of the company, respectively. That there were allegations that lower level employees engaged in bribery of government auditors and the underpayment of these taxes, but there was nothing that alleged sufficiently that they knew about it, that the CEO and the CFO knew about it. What's different now, and what's part of the pleadings before you and in this record, is not only more detailed allegations of their knowledge, but also a sworn affirmation under penalty of perjury by the former chief operating officer of defendant Symbio. That's at record 467 to record 473. That affirmation under penalty of perjury sets out in great detail how both defendant Jacob Su, the former CEO, and defendant Ching Liu, the former CFO, not only knew about this underpayment of their social insurance and housing fund taxes for years, and a drastic underpayment, 50%, but countenanced it and directed it. And indeed, with respect to Ching Liu, to whom the affiant directly reported, the COO Bagbo Zhou directly reported to Ching Liu, and he avers that he worked very closely hand in glove with the CEO of the company, Jake Su. He said both of them knew about this. And in fact, Ching Liu directed him to bribe a government auditor to pass an audit. That was not before Justice Branston. That clearly establishes at the pleading stage, I would respectfully submit testimonial evidence, and it's testimony in the record. They might not like the testimony in the record. They might not think it's credible. They will have an opportunity to test the veracity of the record. Perhaps a finder of fact will test it.
I've given you extra time.
But thank you. I apologize. That's the difference, Justice Scarpullo. And finally, the last ground on which the Supreme Court dismissed.
I think we're going to have to wait till rebuttal on that. I've given you much extra.
Absolutely, will do.
Okay.
Thank you, Your Honor.
You're muted, sir. You're muted still?
Sorry, I've been on mute for a couple of hours and I kind of forgot where that switch was. My apologies.
I understand.
We're only 14 months into the pandemic. I'll figure out the mute button someday. May it please the court, William Dayhill for the respondents, defendants here. There's a number of things that counsel raised. I'm going to address a couple of them. And first, I'm going to address DDJ. DDJ does not hold that simply obtaining a representation and a warranty eliminates the need for due diligence and inquiry. And in fact, it very specifically says, oftentimes, that will be sufficient. But clearly, with subsequent cases, including cases such as basis yield and HSH Nordbank, which I know Justice Gonzalez was the presiding judge at, court's still looking to analyze whether or not what was reasonable.
I think you have the wrong Justice Gonzalez.
Yeah,
that was Justice Louis Gonzalez. But in any case, let me just ask you, with regard to due diligence, et cetera. I mean, this, as we just heard and the record demonstrates, the parties went everywhere. They went, there was trips in California and Helsinki, and they got Price Waterhouse. Even Price Waterhouse couldn't find this. I mean, they're talking about, and what they've alleged is that these books were doctored to avoid discovery. And they were successful in that. So they had Price Waterhouse and didn't show. They asked specific questions and they were told, no, we do different business differently. We're not like other companies. So where was it? I mean, where did they err, or where were they lacking in their due diligence?
Yeah, yes, Your Honor, and I appreciate that because that's where I was going to go next. If you actually read what they've pled, not the argument that's been made, not what's said in the briefs, there are 2 paragraphs that address their due diligence specifically on the issue that they now say was so important, social insurance. Paragraph 150, which is record page 326, says, we looked at their stuff, we asked them questions, we asked whether or not they paid their taxes, and they said they did. That's 1. 2, on page record 328, paragraph 155, they said, did you pass all your audits? We said, yes, we did, which was a truthful statement. Those are this 100% I have given you of what's actually in their complaint about due diligence concerning this particular issue. Which
so then what was Price Waterhouse doing?
Price Waterhouse was hired. Price Waterhouse was not hired to look at social insurance tax, and their statement in the brief misstates what the complaint says. Price Waterhouse was their financial advisor with respect to the acquisition of an international company with offices across the entire world. They were not hired to come and look at social insurance tax. And in fact,
so they didn't look at it. You're saying they didn't review it.
They don't allege that they did. I know subsequently they do not allege that they did. And if again, I'm asking the complaint.
I understand that what's in the record. I understand what's in the complaint.
And to answer the implication of your question also is, well, why isn't even what you just said enough? Because particularly if you accept the Bao Zhou affidavit, when you look at paragraph 4 of his affidavit, his allegation is that this was a common practice. So we had an existing Chinese company that did business in China, knew how to do these taxes, says that they didn't make other acquisitions because they were concerned about their business practices, knew that there had been an audit here which was disclosed, and the sum total of their due diligence on this issue was, did you pay your taxes? Did you pass your audits? Respectfully, Your Honors, that is not sufficient to establish reliance, and this is the fourth time they're trying to allege this. When you take into account, I'm using the fourth as Mr. Bao Zhou's affidavit, that they're trying to get this before the court. 2 commercial division justices have looked at this and said this does not compute. It does not connect. And with regard to Justice Scarpulli, you raised a question about Justice Branston's decision. And actually, I'm sure I wasn't the only one to notice, counsel didn't respond to your question, because whether or not there was a representation or a misrepresentation is different. At best, Mr. Zhou's affidavit goes to scienter. Now, we think it's even suspect there, but I'm going to focus on the particular question that you raised, Your Honor, which was Justice Branston found that EBITDA was a projection. These were projections as to what would happen. These are non-GAAP items. And what they're saying is, well, we relied on that projection non-GAAP item, and what Justice Branston found, and there's nothing that they've done in any of their briefing to change the result, is that is not a representation, again, upon which you can place reliance, or is it a misrepresentation? I also note, as we point out in our briefs, that this idea that this is tied to so strictly to EBITDA is contradicted by their complaint itself. As we point out, as the EBITDA projection went down, and we disclosed it went down during due diligence, by the end it was down a good 20+% from what it had been when the negotiation started. What happened? The price they agreed to pay went up. So again, the facts that are pled in the complaint itself demonstrate that they did not exercise sufficient due diligence. They're not in a position to allege anything in terms of actionable damages because it's contradicted by what their conduct was, meaning that they would have paid less, in addition to the fact that how are they ever going to prove that there was damage? If they can show that there was actually fraud in the Chinese government, when the Chinese government hasn't said boo, in terms of, despite the fact that this company has paid taxes for years after, presumably at a higher rate, and nobody ever went back and said, gee, why didn't you pay your taxes at a higher level before? I mean, the fact that the Chinese government has never raised a single issue about this speaks volumes about what's underlying this particular case.
Right. We're trying to do the exact opposite, is pay less taxes, not more. Everyone in the world.
Well, and as Justice Sherwood, in the argument, and the transcript was there before the court, as Justice Sherwood made clear, parties making an effort to pay as little in taxes as possible is not in and of itself mean that you've committed fraud. And I know that they've come up with the whole.
What about the 25,000, this suggested bribe? And I mean, what about those issues?
The gift, I mean, the so-called gift, right?
Yeah,
So
the gift by any other name, still a bribe, that one.
Well, actually, Your Honor, their entire scheme hinges around this so-called gift, okay, which is a pretty broad. I mean, so what are they going to demonstrate? They're going to have a fraud claim. Well, somebody gave a gift in a different culture.
I'm sorry, counsel. Whose scheme? Are you referring to your client's scheme?
Well, the alleged scheme from the people that were the lower level employees who were involved in working on a day-to-day basis with whatever business needed to be done, in this case, payment of social insurance taxes. But they're not I mean, that business is sold. Those people are now worked. In fact, I might understand none of them even work there anymore, but it doesn't make a difference. The fact of the matter is that the record shows, by the way, that email chain, which is attached to Mr. Joe's affidavit, nowhere does it make any reference to Mr. Liu or Mr. Xu. Okay, there's a lengthy, and if you read the entirety of it, it's basically people talking, now I have to go and do some more work. Now I have to go and respond. It's a day-to-day business communication. It is not the smoking gun that they've turned it into to try to say now all of a sudden, after they decided that they want to try to exceed the level of escrow monies that have been held, after they had a last minute, notice of claim at the very last second, instead of just trying to deal with that, when they filed a complaint 2 years later after not raising the idea of fraud, all of a sudden there's a fraud claim because they want to try to pressure my client into paying more than what's held in the escrow. If there's no further questions, I've probably gone by my time, and I appreciate your listening.
Thank you. We're back to you, Mr. Wise. You have 2 minutes.
Thank you, Your Honor. This is a question of bribing government auditors. There are facts in the record. If you look at record 470, this is the sworn statement under penalty of perjury of the former CEO of the company. I updated Cheng, that's Cheng Liu, one of the named individual defendants, on Ms. Yang's efforts.
Ms. Counsel, your client says it's only $25,000 and it was done by lower level people. So what?
But this is what this affidavit establishes, okay? It says he directed me and others on the financial team to prepare a gift, in scare quotes, for the government's auditing firm. Mr. Cheng Liu, the CFO of the company, was instructing the COO of the company and other subordinates to bribe a government auditor to pass a government audit. There's a rep and warranty in the SPA specifically, and this is at record 219, SPA 3.24, that reps and warrants that no one bribes government officials. No selling shareholders, the company or any of its subsidiaries or any of their directors, officers, agents, representatives, employees has directly or indirectly paid or delivered any fee, commission, or other sum of money or item of property, however characterized, to any finer agent or other party acting on behalf or under the auspices of a governmental official or governmental authority in the United States or any other country, which is in any manner illegal under the law of that country or under the laws of the United States. That's exactly what this evidence is they did. We're at the pleading stage. This is testimony in the record. Again, they can test the veracity of this and the credibility of this affiant, but this is evidence in the record of bribing government officials, precisely the thing that they were focused on and that they secured a rep and warranty on. We respectfully submit that's a material omission, Your Honors, and it supports the fraudulent inducement claim.
Thank you. Thank you both.
Thank you. Thank you very much.
Maria Vullo, Superintendent of Financial Services of the State of New York versus Park Insurance Company. Just 1 sec. Yeah, go ahead now. Yes.
May it please the court, Michelle Jacobson, Stricken Levan, on behalf of Respondent Appellant Park Insurance Company. Good afternoon, Your Honors.
Good afternoon.
Under New York law, liquidation of an insurance company can only be invoked in extremely limited circumstances. And under the Stewart decision, an insurer facing liquidation must be afforded due process. It is self-evident that a remedy, which is the seizure of property and the death of a company, should only be undertaken with all statutory and due process.
So there was a 15-day trial here. So
yes, it was.
Right. So the due process, there was certainly a lengthy hearing here. Why wasn't it sufficient here to substantiate the claims for liquidation?
Your Honor, one of the key linchpins of due process is notice. Here, we had no report on examination showing adjustments. We had no pleading by the superintendent identifying her proposed adjustments to the financial statements. The verified petition did not contain adjustments to the 2017 financial statements because it only addressed the 2015 and 2016 financial statements. Respondent refused to amend its verified petition to deal with the 2017 financial statement, and that's at our record site 1747, over our due process objection, which was at R1731. As a result,
because it wasn't audited, right?
No, they refused to amend their verified petition to show us what they found incorrect with our 2017 financial statement. The 2017 financial statement had been audited, but what I'm saying, Your Honor, is that they at the hearing, we were faced with a moving target, and they were, putting on evidence from the stand, to describe adjustments that they felt were appropriate to the financial statement. But the verified petition did not have those adjustments in them. In fact, there was only one adjustment that was contained in the verified petition that held over to the hearing, and that was the $530,000 surplus note. Everything else was first disclosed by the superintendent in either hearing exhibits or from the stand, and some of the adjustments were not even done until rebuttal and even in post-hearing briefing. We objected numerous times.
Counsel, didn't the petition also cite the insolvency as of 2015 and 2016 based on the negative opinions by your independent auditor? Did not the petition say that?
Yes.
So
yes.
It wasn't just the 2017 states, correct?
No. In fact, Judge, at the hearing, on the first day of the hearing, on December 4th, the superintendent told the court and told us that the basis for their petition would be the 2017 financial statement. It was not going to be the 2015 and 2016 financial statement. The evidence that they put on with respect to adjustments were solely adjustments to the 2017 financial statement. And we did not have notice of those adjustments. And we made objections on the record numerous times about the moving targets and about the evolving contentions of the superintendent. And those can be found at 1660 to 61, 3300, 3986, 1731, and 1720. And essentially, the fact that we did not have notice is, it shows that we did not have all the protections of due process. It was not enough that we had opportunities to cross-examine. That's not what due process requires here. And I would say that under insurance law section 1309, there's a financial statement showing insolvency, which the the 2017 financial statement did not show insolvency. It showed it showed solvency. It shows and it showed $3.3 million of surplus, which is assets over liabilities. So we did not have a financial statement showing insolvency. And importantly, we did not have an examination report. You know, the examination reports are required to be conducted every 3 years by the superintendent, and she did not conduct one since 2011. When a superintendent conducts an examination, a report comes out and the report will contain the adjustments to surplus that the superintendent feels is appropriate. We did not have the benefit of an examination report because the superintendent did not follow the law and did not conduct examinations for 2014 or 2017. And we did not have the benefit of a verified petition or pleading or anything else which would give us a roadmap to what this claim really was. So we had. Did you?
I thought you were finishing up. I'm sorry.
Oh, no.
Your time is up as of now, 6:04. So let me hear from Mr. Del Pozo. You're muted still.
Sorry, Your Honor. Thank you, and may it please the court, Eric Del Pozo for the State Department of Financial Services, or DFS. The liquidation.
Counsel, why don't we pick up from where counsel left off about the fact that they didn't have notice of adjustments. There were all these different adjustments, which really made the difference here between the liquidation and not having a liquidation.
Yes, Your Honor. There was ample and adequate notice of all of the adjustments. I'll point out, as one of Your Honors did, that the petition was based on the 2015 and 2016 audited financial statements, both of which got negative opinions with enough adjustments to render Park insolvent. Park introduced its 2017 statement.
But counsel was saying that you were only relying on 2017. Those other things did exist, but you were only relying on 2017 at the hearing.
That's right. Park introduced its intervening 2017 statement submitted after the petition had been filed, and DFS sent Park a pretrial chart with all of the adjustments that it was going to persuade the court about. And those adjustments, as far as the accounting, most of them were transactions that occurred in 2017, couldn't have been pleaded in the complaint. One of them, in fact, the $2.55 million note received from the related entity occurred after the petition was filed and violated the court's TRO. So there was plenty of advance notice. Park was able to contest these adjustments, introduce their evidence. There was a 15-day hearing. Matter of Stewart held that due process requires a plenary and full hearing. Park got one. It lost, and it absolutely deserved to lose for any of three independent reasons, none of which my adversary, Ms. Jacobson, addressed. The first is that Park is insolvent, both because of its improper accounting and because of its dramatic understatement of its reserves, as Supreme Court correctly held. The second is that Park, irrespective of solvency, is operating hazardously in a way that potentially puts the public at risk and the insurance market at risk. That's number two. And number three, Park has engaged in a litany, no fewer than 5 that we've cited in our brief, intentional violations of the insurance law, any one of which would independently suffice to warrant Park's liquidation. So the court can take its pick of all of those bases.
Are you done? Thank you.
I would, if the court has no other questions, I'd like very briefly to address one main legal argument that Park has made, and that is that DFS wasn't entitled to proceed from a financial statement and show insolvency without an examination. The statute 1309A contains a disjunctive. It doesn't prefer one method or the other. It says that DFS can proceed on a financial statement or a report on examination. And an examination here was, as multiple DFS witnesses testified, unnecessary for a number of reasons. One, it would have cost a lot of money, and that money would have come from Park. DFS is trying to preserve an estate in liquidation, not drain it. Number two, would have caused considerable delay, whereas DFS wanted to proceed expeditiously. DFS already knew full well this company's litany of financial troubles and behavioral issues, as we've cited them in our brief. The Supreme Court laid them out in its opinion, and including disobeying DFS's orders to cease issuing insurance policies or renewing insurance policies without permission, which this company did throughout the proceeding and continues to do to this day, as far at least until the court's stay pending appeal. And the last is that an examination requires cooperation. You only get as much information as a regulator as the company is willing to give you. And this company, Park, has proven itself demonstrably to be uncooperative. And that's why DFS proceeded on the financial statement as it was entitled to do under 1309A. If this court has no other questions, we rest on our brief.
Thank you. Ms. Jacobson, back to you.
Yes. First of all, this is the first contested liquidation where there was not an examination. This really is unprecedented. And the remark that Park would not have cooperated, there's no basis for that in the record. In fact, Park welcomes an examination and actually suggested that one be accomplished. With respect to the point, I would like to make the point that the judge's delay violated section 7417, finding Park to be insolvent based upon a 2017 financial statement in late September 2020. Park's 2019 audited financials show 7.3 million in surplus, 2020 9.8 million surplus, and first quarter 2021 shows 11 million in surplus. And I would say that despite all of the vitriol about Park being hazardous and being a bad actor, the lower court did not make that finding under 7402E, which requires a finding of hazard after an examination. There was no examination of Park, therefore they cannot show hazard. The citation to other orders that Park allegedly violated is unavailing. Not every allegedly violated order subjects the company to liquidation. Only those specifically enumerated in section 7402. And lastly, Your Honors, I would like to say that this company fulfills a need in the marketplace and for the public. It is the largest insurer of ambulances and also insures commuter vans and other commercial vehicles. Without Park, many of these vehicles will not operate, causing the loss of numerous jobs and public access to much needed transportation, particularly during this pandemic. It would be a miscarriage of justice and contrary to the insurance law and the state and federal constitutions to put Park out of business based upon a stale financial statement. And we respectfully urge the court to reverse the lower court's decision in its entirety. Thank you for your time.
Thank you. Thank you both. This is the last case of the day and concludes oral arguments for today. Court is adjourned.
Thank you.